petitioner as a village accountant. There is no order from the deputy commissioner. The deputy commissioner person and order to register some other persons. My name is not in this, but the consider police is prepared to complain to the against.
If it's a criminal complaint which has been filed, why are you coming before us? Before registration only bunny. Next week thought. Next week. Vacating ಕೇಳ್ತಾ ಇದೀರಲ್ಲಪ್ಪ ಕೊಡಿ, it will come in the regular course. ನೀವು ಇಲ್ಲೇ not tomorrow. It will come in the regular course. No exception required to be made out unless there is an emergency. 22nd ಏನಾಗ್ತಾ ಇದೆ? Sorry. It will come in the regular. Emergency idre we'll understand. This is not an emergency. Please give.
Witness production, my lord. Petitioner is eyewitness of murder incident. Jothe 164
Witness protection. Serve ಮಾಡಿ Monday. Memo alla sir ಮಾಡಿದ್ರು. Petition serve ಮಾಡಿ memo ಇಲ್ಲಿ ಕೊಡಿ. Tuesday.
Your lordship judgment of the Lord is for 600 square feet lot. No plan is required. I am constructing only 400 square feet lot. Upon the petition has taken the entry model the building or construction as start. Almost floor has now.
LB matter ಆಗುತ್ತೆ ಅದು ಇಲ್ಲಿ ಹೆಂಗ್ ಬರುತ್ತೆ?
ಅಲ್ಲ, GM not there. GM ಅಂತ ಹಾಕೊಂಡು ಮಾಡಿದ್ದಾರೆ.
ಎಲ್ಲ ಕ್ಲಾಸಿಫಿಕೇಶನ್ GM ಮಾಡಿದ್ರೆ. We'll have to send it to the appropriate bench. Told him Tuesday.
Their classification is
wrong classification. Tuesday told you cuts.
PMRCL tender matter. The writ petition which are filed.
That
My lord,
outdoor.
Today,
My lord, that matter was supposed to be listed today, my lord, that Indian outdoor advertising matter.
Not listed today.
It was today given at 2:30, it's not come up, my lord. Could it be taken up on Monday or Tuesday, my lord? If it's-
Anyway, it would not reach today.
Monday or Tuesday?
Monday at
both
2:30.
the memos.
Monday, my lord?
Monday at 2:30.
Monday at 2:30.
ಅದು ತಗೊಳ್ಳಿ, ಅದು Monday 2:30.
ಎಮರ್ಜೆನ್ಸಿ
Grateful.
ಪೆರೋಲ್ ಮ್ಯಾಟರ್ ಮೇಡಮ್. ಎಮರ್ಜೆನ್ಸಿ ಪೆರೋಲ್ ಮ್ಯಾಟರ್.
ಏನಾಗಿದೆ?
ತಾಯಿ ಹಾಸ್ಪಿಟಲೈಸ್ ಆಗಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಏನಕ್ಕೆ ಹಾಸ್ಪಿಟಲೈಸ್ ಆಗಿದ್ದಾರೆ?
ಆಪರೇಷನ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿ.
ಏನ್ ಆಪರೇಷನ್? ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿ.
ಮೆಡಿಕಲ್ ಡಾಕ್ಯುಮೆಂಟ್.
ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಏನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ?
ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ ಪೆರೋಲ್ ಜೊತೆಗೆ.
ಯಾಕಂದ್ರೆ ಅವ್ರು ವೆರಿಫೈ ಮಾಡ್ಬೇಕಲ್ಲ.
ಅಟ್ಲೀಸ್ಟ್ ಅದು ಫಸ್ಟ್ ಟೈಮ್ ಮ್ಯಾಟರ್ ಸ್ವಾಮಿ ಹಂಗಾಗಿ.
ಸರ್ ಮಾಡಿ ಎಲ್ಲಿ ಯಶೋಧ ಇಲ್ವಾ? ಅವ್ರಿಗೆ ಸರ್ ಇಲ್ಲಿ ಪೆಟಿಷನ್ ಸರ್ ಮಾಡಿ.
ಓಕೆ ಸ್ವಾಮಿ.
ಸೊ ಅವ್ರು ನೋಡ್ತಾರೆ ನಾಳೆ
ನಾನು ಶುರು ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ.
ನಾಳೆ ತಗೊಂಡು.
My lord, challenging the order dated 10/11/25, my lordship. District Commissioner issued the NBW issued the against the petitioner, my lordship.
ಸ್ಟೇಟ್ ಕನ್ಸ್ಯೂಮರ್ ಕಮಿಷನ್.
ಹೌದು.
ಮತ್ತೆ ಇಲ್ಲಿ ಹೆಂಗ್ ಬರ್ತೀರಾ? ಸ್ಟೇಟ್ ಕಮಿಷನ್ಗೆ ಹೋಗ್ಬೇಕು.
ಕಮಲಾಕ್ಷಿ ವಿವಿಧೋದ್ದೇಶ ಸಹಕಾರ ಸಂಘ. ಅಲ್ಲಿ GM
KPID ಆಗಿದೆಯಾ ಏನು? Is it part of the KPID? KPID ಅಂದ್ರೆ will interfere. Otherwise, it's appeal is available for you.
ತಮ್ಗೆ ಬರುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರು.
ಚೆಕ್ ಕೊಡಿ ನೋಡೋಣ.
ಅಲ್ಲ 20 ನಲ್ಲಿ ಬರುತ್ತೆ ಅಂದ್ರೆ ಅಲ್ಲಿ.
Senior Citizens Act, cancellation of deputy. This is the third time I'm mentioning a name before your lordship.
Is it a pending matter or a fresh matter? Fresh matter ಯಾಕೆ ಬರ್ತಾ ಇಲ್ಲ?
She's 85 years old.
Fresh matter, most of it is cleared now. There is no fresh matter which is pending. We are getting only the last 3 days filing only we are getting now. Fresh matters ಯಾವುದು pending ಇಲ್ಲ.
ಇಲ್ಲ ಸರ್.
ಯಾವುದು ಇಲ್ಲ. ನೋಡಿ ಅದು ಯಾಕೆ ಬರ್ತಾ ಇಲ್ಲ? Unless there is compliances.
It's been complied.
Unless there is compliances, all fresh matters are cleared.
Last month it was complied.
Fresh matter are pending. ಕೊಡಿ.
My lord, fresh matter, my lord.
ಒಂದು ನಿಮಿಷ ಲೈನ್ ಅಲ್ಲಿ.
Registrar refuses to register the sale deed on the ground that the son has written a letter to him to say that the mother who is the grantor of the power of attorney is no longer there. She is dead. So I challenge that refusal to register.
We'll have to go for a civil suit. We can't deal with it.
The direction I have.
if you want to rely on our earlier judgment.
Yes, my lord.
Yes, but there's an objection.
My lord, sir.
ಕೊಡಿ ಕೊಡಿ. ಹೇಳಿ.
Deputy Commissioner case against some of the parties.
ಕೊಡಿಪ್ಪ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ. ನಾಳೆ CMP day, it can't come up tomorrow, it come next week. ಕೊಡಿ. ಬೇಡವಾ ನಾಳೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರೋದು? ಕೊಡಿ. ನಾಳೆ ಅಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರೋದು. ಸ್ಯಾಟರ್ಡೇನಾ? ವರ್ಕಿಂಗ್ ಡೇ. ಬನ್ನಿ ನೀವು ಬನ್ನಿ.
My lord, if I may.
My lords, kindly, my lords, steps are being taken in spite of the interim orders of this honorable court, my lords, to deregister the hospital. My lords, poor people are being treated in the hospital, my lords, without giving me an opportunity. The steps are being taken to
Deregister the hospital. So
My lords,
Monday.
My lords, it may be taken in preliminary hearing. My lords.
Monday. Pending matter or fresh matter?
It's a preliminary, it's a pending matter, my lords. But in spite of the interim order, my lords, they are threatening to take action, my lords, contrary.
There's an interim order already passed.
Please, my lord.
it cannot be threatened by officer. They will have their own fear, my lord. They will lose their job. It's not like that. Submission, I cannot.
There's an interim order, how can you do it?
ಅವ್ರು ಮಾಡೋದಿಲ್ಲ, ಯಾಕಂದ್ರೆ ಅವ್ರು ನೌಕರಿ ಕಳ್ಕೊಂಡ್ಬಿಡ್ತಾರ. ಮ್ಯಾಟರ್ ಬರಕ್ ಹೇಳ್ತಾ ಇದಾರೆ.
I think any officer will do that once the interim order is passed.
Fresh matter where Indus law is on Wakalat, my lords. Indus law is on Wakalat, it's a fresh matter that we have filed. But it's a writ challenging an order passed by the Karnataka regulatory authority, the real estate authority. There is some urgency because they have dismissed my IA on maintainability without signing any reasons, without even hearing the parties. Well, I understand.
Regulatory authority, appellate authority you have to go to.
Well, it's a complete disregard of natural justice principles, my lords. Well, they're
Kodi.
My lords,
230, please, my lords.
Not 230.
My lords, it's a GM tender matter, my lords. It was
This,
Some urgency.
what is the urgency in a RERA matter to be taken up at 2:30, Mr. Counsel?
Well, it's coming up on 24th for final arguments on all issues finally.
Yes.
My lords, it's a GM tender matter, my lords. It was listed before your lordships on 17th. However, serial number 65 to 135 were to be heard in court on number 5. Inadvertently, this was missed out, my lords, and the petition was dismissed for non-prosecution. We have since filed an application for.
Two memos, my lords, challenging the very same tender notification, my lords. Notice is issued. Both the parties have settled, my lords. I want to withdraw the petition for tomorrow.
These are settled in a tender matter. Monday.
Tomorrow, my lords, if possible.
Tomorrow is CMP day.
Monday, my lords.
Senior citizen pending
Two
matter. It was moved on 30th and directed to be listed on 10th. But till yesterday, it was not listed. Yesterday, it was listed before the restart discord directions. Restart ಮುಂದೆ ಬಂದ್ಬಿಟ್ಟಿದೆ.
If there are compliances to be done, it will go before the registrar.
ಅಲ್ಲ, ಅವರು 9 objection ಕಂಪ್ಲೈ ಮಾಡಿದೆ, ಇಂಟ್ರಿ ಮಾರ್ಡರ್ ತಗೊಂಡಿದ್ದಾರೆ. ನಾನು ರೆಸ್ಪಾಂಡೆಂಟ್ ಅದರಲ್ಲಿ. I am put at difficulty. Court has said list it after 4 weeks in June. ಬಂದಿಲ್ಲ ಮ್ಯಾಟ್ರು. They have not complied with the office of 9 office objections.
You are the respondent.
Please.
The stay order.
Father, yes.
Tuesday.
Urgency is that, my lord, instead of filing the civil suit, my lord, eviction, the opponent, they have filed the commercial suit. In the commercial suit, my lord, the expeditious trial, my lord, they are trying to evict me as early as possible, my lord.
So how will it come before us? If at all commercial court.
Commercial suit.
Commercial suit andre commercial appeal if you are aggrieved. GM res ಹೆಂಗ್ ಬರುತ್ತಪ್ಪ? IML ಬರಲ್ಲ. 13 only goes on appeal. Commercial court appeal ilva. Please see the provision. You're wasting your time. Dismiss agate. Please check properly.
My lord, fresh matter, my lord, seeking police protection against my lord.
Order is passed by trial court for police protection. Allilla andre we can't enforce it.
For the petitioner brought here, EAP has passed an interim order with respect to only one survey number 55, whereas the mining authorities have issued notice to the adjoining survey number, which is not a subject.
Good.
Please, Monday, Lord.
We can't stop annual general body meeting being conducted. AGM of all the members in 2 days ನೀವು ಮಾಡಂಗಿದ್ರೆ ಅದು ಬರುತ್ತೆ. ಬರುತ್ತಪ್ಪ ಕೊಡಿ.
they are not submitting, the complainant has withdrawn the complaint, and now they are not doing the investigation.
Pending matters will come in the sequence of matters that will come. Everybody has urgency. We can't, that 19,000 cases pending in this roster. Everybody has urgency. Agalla, it will come in sequence. Kodi.
If I may, that's 20 seconds of your time. But in the matter that just I moved against the JARA authority matter. The JARA authority memo that I just tried for moving. But I understand the matter may have to be placed before some other bench because interest was on record. So please keep it today to pass appropriate.
No, we can't take it up like that for today. It will come up on Monday. We'll see that. Kudi.
Adjournments. Number 1, page number 6, serial number 38. Page number 7, serial number 39 to 45. Page number 8, serial number 46 to 51.
ನೀವು ಯಾರಿಗೆ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ಇದಾವೆ ಎಲ್ಲರಿಗೂ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀರಾ ಯು ಆರ್ ನಾಟ್ ಇನ್ಫಾರ್ಮ್ ದೆನ್ ಪ್ಲೀಸ್ ಡೋಂಟ್ ಮೆನ್ಷನ್ unless the other advocate is here. Then whenever it is listed, please come at that day when you're free. When it is listed without informing, please don't mention. Next.
Page number 9, serial number 52 to 55. Okay.
Yavadama? 54. Have you informed the respondent? Please don't mention.
Page number 10.
51 ಅಲ್ಲ 54.
54.
Serial number 60.
That's serial number 60. May I request my lords to have it in the next week, my lords?
It will go to third week.
The second week of December, my lords.
15th December.
Please, my lords.
Serial number 64 to 69.
Counsel for the petitioner, 15 December.
Page number 12.
64. For the caveat respond number 6.
Yes.
Kindly have to file report.
We inform the petitioner. Don't mention, please.
Page number 12, serial number 70 to 75.
My lord, serial number
70. At the request of counsel for the petitioner, released on 15 December.
My lord, serial number 74, my lord. Kindly have it on Wednesday.
Respondent?
Yes, yes.
Same.
Lord, 75, my lord, I will give document, it may be closed, my lord. What he sought information, my lord, that is ready.
You are giving the information. Please see the information. Please check the information and let us know if it is proper. Yes, next third. Ashton.
List number 1. Test matter, serial number 1.
My lords, I apologize, my lords. Serial number 106, my lords, list 1. List 1, my lords, serial number 106. My lords, the matter, my lords, it has to be connected with WP 324325, my lords. It is on 412, my lords. It may kindly be adjourned to 4.
So and so and released on 412. Office objection if not complied by next date, petition will be liable to be dismissed for non-prosecution.
IO may kindly be extended.
IO extended till next date.
Serial number 97, my lords. I appear on behalf of the petitioner.
97.
Yes, my lords. To inform the respondent.
Appearing, my lords.
My lords, the senior counsel has some inconvenience, my lords. Your lordships may have it.
You are for the petitioner.
Yes, my lords.
Have you informed all the respondents?
I have informed, my lords.
My lords, I'm appearing for the respondents, my lords. While we don't oppose the inconvenience cited by the petitioner, my lords, we have it on a short date, my lords. You filed an IA for vacation of stay. They're sitting on an interim order, my lords.
Next date will be 15 December.
Well, they have not complied with office objections as well.
97 released on 15th December at the request of counsel for the petitioner. Interim order earlier granted is extended till next date of hearing. Office objection on the statement of objections to be complied by next date. Failing which, statement of objection will be struck off from the file.
My lords, it's serial number 127, my lords.
127.
Kindly may I have it on Wednesday, my lords. Kindly may I have it on Wednesday.
To comply with the office objection, Mr. Counsel.
I will comply. I will comply.
Seeks fund is granted 2 weeks time to comply with the office objection released on 11th
Date
December.
may be given on Wednesday, my lords, please.
11 December.
Mention madadala, sorry, 76 months. You mentioned. Lord,
This number-
that is different matter, my lord. 75 hour ಹೇಳಿದ್ದು ನಾನು 76 ಹೇಳಿದ್ದು. Confusion.
70. 70. ನೀವು 76.
76 ಅಲ್ಲಿ he sought for information, but 75 that different matter, consumer ಅವ್ರದ್ದು. I think
But
party
giving it
person
is
ಅದರ ಅಂದ್ರೆ
75.
ಇವರೇ ಅದರ ಅಂತ ನಾನು ಹೇಳಿದೆ.
Yes, Mr. Satisha, what do you want to say? 76 it is. You are Mr. Satish.
He is appearing for 75 is a respondent party in person.
Respondent party.
House.
Yes. What is it? Make a,
I had put aside in the year 2011.
are you mentioning the matter or are you arguing the matter? What is the mentioning that you want to do?
From the district commission, it has been ordered on 24th July, 24th January, that they had to pay part of the amount paid plus 9% interest from the type.
ಅವ್ರಿಗೆ ಹೇಳಿ ಟೈಮ್ ಬೇಕಾ ಏನ್ ಬೇಕಾ ಅಂತ.
From January 24th, they have not complied till now.
Yes, so what is the mentioning you are doing? You want adjournment?
No, I want to argue.
When it reaches, please, not now.
Sorry.
You are at 75. When 75 reaches, you make your submissions.
List number 1, fresh matter, serial number 1. Hussain Khan, party in person.
My lord, this matter is assigned to me by Legal Service Committee, High Court of Karnataka. My lord, in this matter, the petitioner had got dissolved his marriage in Masjid at Channagiri Taluk, Davangere district. My lord, when he got dissolved in the year 2018, he didn't, the Masjid authorities didn't give the Kulanam certificate, my lord. But they gave a Kulanam certificate to only that wife, my lord. So then he approached
You not
information
make the wife a party. Should make her a party. Alva?
Yes.
Yav file ಮಾಡ್ತೀರಾ?
Next 2 weeks.
Counsel for the, she so and so submit that he has been appointed by the Karnataka State Legal Service Authority to represent the petitioner by providing free legal aid. He seeks for and is granted a week's time to file necessary application to bring the wife of the petitioner on record, since she would also be an aggrieved party. Relist on 9th December.
Great well.
Serial number 2, B.V. Prakash Angadi.
My lord, I appear for petitioner in this case. My lord, I have challenged the order dated 5/4/2025 passed by the Honorable District Court, my lord, allowing the application filed by the petition respondent, condoning the delay in filing the reference, the petition under section 34 of the Arbitration and Conciliation Act, my lords.
When was the award passed?
My lord, the arbitral award passed on 22nd November 2016, my lords.
Page number?
At page number 35, my lords. As per the announced
55, where do we get the date?
My lord, top, my lords, page number 35, 22nd November 2016.
ಇಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ಸ್ ಮಧ್ಯದಲ್ಲಿ.
Case number.
Yes.
This is the order passed by the Honorable Arbitrator, my lord. That was as per the announcement, the order passed by the arbitrator. The respondent has furnished the indemnity bond and on 1/3/2018.
When was this award served on the respondent?
My lord, there is no documents whether it is served or not, my lord.
Then
My lord, my
where do you start
submission
the calculation of the limitation period? How do you start it?
My submission is, as per the enhanced order, the arbitral award, he has accepted the enhanced compensation in the year 2018, my lords.
You have transferred it into his
Yes,
account.
yes, I have produced the documents.
ಅದಕ್ಕೆ ಹೇಳ್ತಾರೆ, you have transferred it into his account. That is not acceptance.
No, he only has come and.
Where is that document?
I have produced. Hold on. Sorry, by filing a memo before the Honorable District Court.
Page number.
My lord, page number 69, my lord. 67 is my memo. Page number 68 is the documents regarding payment of compensation, that is enhancement of compensation.
Where is it that he was aware of the award having been passed?
My lord, he has accepted the compensation amount as per the enhancement made by the arbitrator. My lord,
Counsel, that is what NHA keeps on doing in all matters.
That's-
Does he even know about the award having been passed?
Yes, my lord, he is aware.
Where is that document?
My lord, 69, page number 69 is the indemnity bond executed by the respondent, saying that I am accepting the enhanced compensation as per order of the honorable arbitrator.
69 is your memo that you have filed.
No, 69 is the document.
I respond number 1 and 2, SLO and National Highway Authority are the respondents in that matter. 70 is the voucher for payment.
Yes,
We are asking you a very simple question. Please understand the question.
Yes, my lord.
If you don't understand, we'll repeat it again if you.
No, my lord, I can understand.
Please show us a document indicating the date of knowledge of the arbitral award by the respondent.
My lord, may I make submission? My lord, it is the arbitrator who has to communicate the order, my lords.
You are the one who is saying it's barred by limitation, so you are.
No, my submission before your lordship is that he has executed the indemnity bond on 5/4/2018, accepted the enhanced compensation. My lord, it is clear that he has a knowledge, he had a knowledge of the passing of the award, my lord.
That's your submission?
My lord, he has accepted the enhanced compensation, my lords. Even he has made a statement in the IA, my lord, may your lordship may kindly turn to.
That's the only submission you have.
No, that apart, he himself has admitted that he has a knowledge on 23/8/2018.
Who has that document, Mr. Counsel?
Well, page number 65, he has filed an affidavit, my lord, IA, application for condonation of delay, in which he has stated in para number 2. Mary.
Impugned order has not been coming. That is what
Has
we
not
saw
been
and asked.
communicated to me. So far, only subsequently, when I approached the concerned authority on 23/8/2018, I came to know of the, know about the order immediately. I applied for the same and I got the same on 13/12/2021. He had the knowledge and because of that only he has accepted the enhanced compensation, my lord. Without there being any knowledge or communication, he
Get
could
the
not.
records, AG. Issue notice to respond number 1 to 6. And AG accepts notice for respond number 7 and 8. And look at this way you do it now. Now you have made the SLO respond number 8. Whenever you want, you appear for SLO also. When you don't want, you make him a respondent.
Lord, it is for the sake of.
Now they have made SLO a respondent.
No, we are not claiming he is a formal party, my lord. I mean,
You refuse to accept notice for the SLO.
no, he notice may
Now
kindly be
who do we issue notice to the SLO now?
Notice to SLO may kindly be dispensed, my lord. Since we are not claimed he is a formal party.
You have made them respondent. Who will accept notice really? SLO only the state can accept. AG accepts notice for respond number 7 and 8. He is directed to place on record the file relating to the passing of the award, enhancing the compensation, as also to place on record the date of service of the arbitral award on the respondents.
My lord, I have sought for stay of
We
further
are not
proceedings.
staying.
Alla, ಈ arguments ಗಿದೆ 12.
We are not staying.
ಅಲ್ಲ ಡಿಸೆಂಬರ್ ಗಿದೆ ಸ್ವಾಮಿ ಸುಮ್ನೆ ಏನಾಗ್ತದೆ ಇಲ್ಲಿ
We are not staying, Mr.
ಅಲ್ಲ number of petitions similar line ಅಲ್ಲಿ ಇರ್ತಕ್ಕಂಥದ್ದು very same judge just dismissed and now in few cases.
Released on 4th December. Next.
Great.
Number 3.
Same my lord.
4. Chintan Chinnappa.
My lord, we are appearing for the petitioner in this matter, my lord. In this matter, we are seeking quashing of e-auction sale notice dated 25/5/2025 and auction confirmation notice.
By respond number 1, Cooperative Bank.
It's a cooperative bank, my
The
lord.
cooperative society matter, it will have to go before the other bench. A perusal of the papers indicates that the matter relates to an auction conducted by a cooperative bank. Hence, registry is direct to place the matter before the appropriate roster bench.
Serial number 5, Srihari NS.
Lord, a death certificate is issued, my lords. A death certificate is issued in favor of one Krishnappa. The name of his father is recorded as Chikka Kalappa instead of Chikka Nanjappa. To effect that correction, my lords, a representation is made to the first respondent.
And AGA accepts notice for respond number 1 and 2. He seeks for and is granted 2 weeks' time to obtain instruction, make his submission, relist on 11th December.
May kindly request 12th December.
It will go to 15th, 11th or 15th?
Please, 15th.
15th.
I'm grateful.
Serial number 6, Chetan B.
Copy of the petition, my lord. Lord, the writ petition is for writ of mandamus, my lord, issuance of mandamus. Lord, the petitioner, my lord, has given representation to respond number 1 and 2.
Yes.
My lord, the petitioner, my lord, is the landowner of agricultural land bearing survey number 9/4, 10/2, 10/6, my lord. The adjoining owner, my lord, that is property bearing survey number 104, is obstructing, my lord, the right of way. My lord, though we have given a representation to the deputy commissioner.
Complaint with the police.
My lord, I have complained the
mandamus to the police.
No, my lord, I am seeking mandamus to deputy commissioner as well as the Tahsildar, my lord. My lord, as per annexure A and B, my lord. 12 and 13, my lord.
Jurisdictional police on 15/10.
Yes, my lord. Even I have given complaint to the jurisdictional police as well. Lord, they have not acted upon saying that it's a land dispute. And subsequently, my lord, I have also given representation to deputy commissioner as well as Tahsildar.
No orders have been passed.
No orders have been passed, my lord.
Madam, pass orders. Because that Namma Ola Namma Raste scheme is there. And AG accepts notice for respond number 1 and 2. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the usage of the petitioner of the road giving access to his property has been encroached upon, and that a trench having been dug by third parties, the petitioner is not able to access his property. The respondent representation, submitted on 16/10/2025 to respond number 1 and 2. No orders have been passed by them till date. Whenever any representation is passed to a authority, state authority, it is required for the authority to consider the said application stroke representation and pass necessary orders within a reasonable period of time, either accepting or rejecting the request made. Needless to say, if a rejection order is passed, it should be followed by reasons. Neither having been done and the representation having been kept pending, I pass the following order. Writ petition allowed, a mandamus is issued directing respond number 1 and 2 to consider the representations dated 16/10/2025 and annexure A and B respectively, and pass necessary orders within a period of 10 days from the date of receipt of copy of this order.
Obliged.
7, Srinivasa Gowda.
For petitioner, my lord.
Hmm.
My lord, the petitioner is seeking a writ of mandamus. The petitioner had made a representation to the respondent 2 and 3, my lord, to extend the period of lease.
Extend the period of lease.
Please, my lord, via annexure C, my lord.
Get instructions. And AGA accepts notice for respond number 1 and 2. Shri Shanti Bhushan and DSGI is directed to accept notice for respond number 3. They seek for and are granted 2 weeks time to obtain instruction, make the submission. Released on 11th December.
My lord, the similar matters has been disposed, my lord.
How can we ask them to extend the lease in a forest land?
Please, my lord.
Let them get instruction as to what it is.
Please.
So now the latest Supreme Court judgment says all the leases.
Please, my lord.
Serial number 8.
Here for the petitioner. This is relating to adjusted gross revenue, my lord, with respect to telecom companies. In our case, my lord,
the entire licensed activity never started. That's an admitted position.
Never
And
started.
Never started, and it was thereafter cancelled. At my request, my lord, it was cancelled in the year 2020 itself. Now, my lord, they make a demand, and they've been making a demand for some time, saying pay adjusted gross revenue on your other income. Gross
show cause notice.
No, this is a demand notice.
Demand come show cause notice.
But what has happened is we've responded to all of this. Now they've not only this is a supersession of all other demands, and then your lordships will kindly see page 27, which is subsequent. Last 4 lines. Hence, you are hereby called upon to make payment of total demand of 5 to 10 lakhs, raised by the up-to-date interest up to the date of payment. Non-payment of demand. Actually, this was in that 2019 judgment is covered. Same issue, where spectrum is not allocated, because spectrum has to be allocated. Without that, I can't start my license activity. And this is on the revenue model, not on the fixed fee model. Therefore, Supreme Court held that if license activity has not started, then the license does not come into effect. Therefore, the question of payment of any sum of money does not arise. I have an entry fee which I had to pay at the time of obtaining the license. That is, of course, gone, Lord. At para 163 of this judgment, may I just pass it on? The pre-judge bench judgment.
So you never started your...
I never started. That's an admitted position. I'm sorry. Para 163, my lord.
And this is a good way of getting iPads to the court.
I'm sorry. I think your lordship must not return it now.
Any iPad sent will not be returned.
That's what I'm saying. That's the danger of it.
Will be given to the court clerks.
But it might get locked after some time.
That we'll ask you for.
The last one. Once there is at page 616, your lordship will see.
Without a spectrum, license cannot work. No activity.
It says once there is no activity under license, merely on the basis license is an issue, no revenue and it cannot be shared. Still, there's no activity under license.
Who appears for the respondents?
I'm sorry, Mr.
Who appears for the respondent? Who should take notice for respond number?
I think Union of India only.
First Department of Telecommunication, Bengaluru. Who is for respond number 1 and who is respond number 2?
Both are actually the same. It's a DOT itself. So maybe it will
Both are
serve.
central.
Both are central government. It's only the office.
Shanti Bhushan and DSGA is directed to accept notice for respond number 1 and 2. The categorical submission made by Shri Dhyan Chinnapal and senior counsel is that the spectrum was never allocated to the petitioner, and as such the business of running ISP services was never started by the petitioner. And in this regard, he relies upon the decision of the Honorable Apex Court in Union of India was Association of Unified Telecom Service Providers of India. 2008, 1 SEC 1.
No, 2023 SEC.
2020. 2023 SEC.
525.
5 more particularly para 163 thereof. A parallel of the said paragraph clearly indicates that if spectrum was not allocated and business had not commenced, it would be unreasonable and unconscionable to levy any liability on the license holder who has never commenced business. In that view of the matter, the operation of Annexure A, B, C, and D, so and so, are stayed till the next date of hearing. Counsel for the petitioner shall furnish 2 sets of the petition along with annexures on the learned DSGA and file an acknowledgement thereof by end of day tomorrow, failing which the interim order will stand automatically cancelled.
Great.
The iPad has been returned to the council.
On this occasion. Next time we'll be careful.
A1 of 25 is allowed.
Serial number 9.
That is because it's the instructing councils.
I'm holding mine carefully.
You are very careful. If that had come, it would not have gone back.
Serial number 9.
Is Dilraj?
For the petition,
Parole. And AGA accepts notice for the response. She seeks for 10 days time. Released on 1st December at 2:30 p.m.
Serial number 10.
petitioner in this, my lord, that impugning the RBI ombudsman order, my lord. An order was passed closing my complaint without giving me an opportunity. to
Closing
withdraw.
your complaint.
Yes, ma'am. That's at annexure A, my lord.
Shri
Page number
Pradeep
6.
Saukar is directed to accept notice for respond number 1 and 2. Issue notice to respond number 3 and 4, returnable by January on date.
20th January,
I'm obliged.
serial number 11, H. Ramachandra.
My lord, I'm the petitioner, my lord. My lord, in this, petitioner has made an application to run a Nandini parlor in Irangere Primary Health Center, my lord.
Run a?
My lord, a Nandini milk parlor, my lord.
Nandini milk parlor.
Yes, my lord. In Irangere Primary Health Center.
Hmm.
My lord, he made the representation on 23/8, my lord. His representation is at page number 30.
Want to
annexure
run a
E.
parlor in the health center?
My lord, my lord, there is a government scheme which
Outside the
allows
health center or inside?
outside, in the premises, my lord.
Outside better.
Sorry.
In andre kashta.
Yes, my lord, this particular scheme was for handicapped and ex-servicemen and SC/ST personnel, my lord. Petitioner belongs to scheduled caste community. He made this application on 23/8/2024, my lord.
Where is that scheme?
My lord, it is at annexure A, my lord. My lord, annexure A starts at page number 11. The typed copy starts at page number 14, my lord. This is a government notification. My lord, it provides for milk parlors across various districts, my lord, and also to whom all is applicable. My lord, annexure L is the endorsement that's being challenged, my lord. In that, if I may read out, my lord, they state that on 7/8/2025, it's already been allotted to a third party. They have not assigned any reasons and not given any opportunity as why his application has been rejected. And this is dated 7/8/2025, my lord. Whereas a year earlier,
Reason as to why it is rejected.
Yes.
There are 10 applicants who have
My lord,
applied. One of them will get it. Unless you show that the application allotment is mala fide or biased.
my lord, my
Challenge that.
application was made in fact a year prior, and in fact there was an endorsement by the director of the Milk Producers Federation, my lord, to consider my application also, and that is also dated September 2024, my lord. That is at annexure G, my lord. My lord, it's dated 17/9/2024, wherein it was directed to consider my application also.
Who has it been allotted to, madam?
It has not been stated, my lord.
You have not stated.
Not stated also.
How will they make them a party? They have to be made a party. Correct. You produce them, but the person who will be affected is the person who is allotted. He has to be made a party, so he is also to be heard. Learned AG accepts notice for respond number 1 to 10. She submits the details of the person to whom the allotment has been made will be provided to the petitioner in 3 days' time. Counsel for the petitioner seeks for and is granted 10 days' time thereafter to file an application to implead the allottee, released on 11th December.
12, yes, Kalyan Basuraj.
Petitioner being a mandamus to issue renew passport without the father's consent. The parents have are divorced and the custody is with the mother. Father has visitation rights. In fact, I've been writing to the father.
Yes, for respond number 3 in any proceedings.
Yes, my lord. 310 annexure B, civil petition 310/2024.
What's the name of the counsel?
Yes, my lord. V. Krishnamurthy anta. Hitaishi V. Krishnamurthy, my lord.
V. Krishnamurthy. And Ms. Reshma KT accepts notice for respond number 1 and 2. Shri Krishnamurthy?
V. Krishnamurthy.
Shri V. Krishnamurthy, who had appeared for the respond number 3 in other connected proceedings, is directed to accept notice for respond number 3, released on 9th December.
Fresh matters.
Preliminary hearing.
Obliged.
13,
Post before a bench of which SGRJ is not a party.
14, Ketan Kumar.
I sought for mandamus against the respondent. Initiate action against the respondent number 5 police, my lords, on 29/10/2025. Subsequent to that, my lords, a series of action initiated by the respondent 5 against the petitioner, my lords. Annexure 8, page number 15 is the complaint cum representation submitted by the petitioner. On 23/10, my lord, 2025, one unseen a stabbing incident has been occurred nearby of the bar and restaurant of the petitioner, my lords. Subsequent to that, my lords, respondent police official attached to the respondent number 4, in the guise of investigation, they're every day visiting the bar and restaurant of the every day, and asking, it's out of the record, they're asking premium liquor bottles from the petitioner's restaurant. For that matter, he has submitted a representation to the commissioner of police.
Don't sell premium.
Sorry, my apology.
What is this?
I sought for interim prayer.
He accepts notice for respondent number 1 to 4.
Subsequent to that, many
interim prayer inkodakage.
ಅಲ್ಲ ಆಮೇಲೆ ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ
let the AG get instructions.
Kind of for a minute, my lord. Thereafter, my lords, respondent number 5 took the children of his employees to book the case against the petitioner under Child Labor Act. Since they are aged about 16 and 17, he has not unsuccessfully registering the case against the petitioner.
Children of
his employees reside in third floor of the restaurant, my lords. Kindly see the notice issued to the parents of that 2 children.
Let's get instructions.
Thereafter, my lords, he has wrote the excise department
from 1 to 5. She seeks for and is granted a week's time to obtain instruction, make a submission.
My lords, meanwhile,
released on 1st December.
In preliminary, meanwhile, my lords, not to interfere business of the petition with legally.
What is that relief? Not to interfere in the artha. What is the meaning of?
My lords, now he has successful registering case under Excise Act, my lords, under section 20 of the Act.
If there's some violation, they'll register it.
Illa, they are the students studying in sound Rajadal Bandavar
by 1st December.
My lords, meanwhile, not to take any coercive steps against.
Can't do that in preliminary hearing.
Preliminary hearing, my lords.
15, Vasudevan Naidu.
Yes, Mr. Naidu.
My lordships, petitioner is a contractor awarded with the
invoking the bank guarantee.
Bank guarantee. Final notice was issued after completion of the work and after completion of the maintenance period also, my lordships. And the bank, this bank.
There is a contractual issue.
Contractual issue.
So why are you coming as a writ petition?
My lordships, now the work is completed, my lordship. 24 months work is completed in the year 2021. And the maintenance period also completed.
Yes.
Now there are some disputes. They have to pay money of about 21 crores now.
Is there any arbitration proceedings or
arbitration
civil
proceedings we are about to initiate now, my lordship.
Then in that file is section 9 for this. Not as a writ petition.
Now there is an apprehension of threat that they may invoke. The bank guarantee is valid up to 26 December, my lord.
You had the time to file this petition before this court. You have the time to file a section 9 proceedings. Please file an appropriate proceeding, not this. Land AG accepts notice for respondent number 1 to 3. Petitioner is before this court seeking for the following reliefs. Essentially, what the petitioner has sought for is for an order restraining the respondents from invoking a bank guarantee which has been furnished. The matter arises out of a contractual dispute, if at all arises out of a contractual dispute between the petitioner and the respondents. On inquiry, learned counsel for the petitioner submits that the contract between the parties is governed by an arbitration clause. If that be so, reserving liberty to the petitioner to initiate such appropriate proceedings as may be advised, the petition stands disposed.
16, Kumar NB.
I'm for the petitioner, my lord. Yes. Lord, I sought for a direction, my lord, to the respondents to register an FIR, my lord. The petitioner, my lord, has filed a written complaint, my lord, on 6th April 2025, alleging that his neighbor is involved in cultivation and consumption of ganja. In spite of providing videographs and photographs, my lord, no action has been taken.
Where are the photographs?
Page number 30, my lord.
Page?
30.
Madam,
He has
people have
approached-
come to you to take action, you don't take action.
He has approached ACP, DCP, and all other authorities, my lord.
Whatever their neighborhood problem may be, but he has come with the offense.
The petitioners.
And AG accepts notice for respondent number 1 to 6. She seeks for and is granted 2 days time to obtain information, instruction, make a submission, relist on 24th at 2:30 PM.
17, Sriram T. Nair.
Yes.
Well, it's family dispute. Few people come into my house and they assault me. FIR is filed against 14 members, 8 to 9 unknown individuals.
Further investigation is complete or?
Investigation is complete. In the charge sheet, only 5 members have been included. Kindly come to page number 38. Manoj. Page number 38 is a part of the charge sheet. ಇವರೆಲ್ಲ ಅಸಾಲ್ಟ್ ಮಾಡೋದಕ್ಕೆ ಹಿಡ್ಕೊಂಡಿರೋದೆಲ್ಲ ಮಟೀರಿಯಲ್ಗಳು ಕೈಲಿದೆ, ಅವ್ರನ್ನ ಯಾರನ್ನೂ ಇನ್ಕ್ಲೂಡ್ ಮಾಡಿಲ್ಲ. 1, 2, 3, 4 until page number 40. 4 members who are visible in the videographs, which is a part of the charge sheet. They have assaulted me brutally. They have left them out. And in page number 38, it can be also seen that he is holding a metal rod.
When was the charge sheet filed?
The charge sheet is at page number 29, Manoj, Annexure D. ಹದಿಮೂರು ಆರು 25, 20/8/2025 charge sheet date. It was confirmed on 4/9/2025. Check and put up. Seal ಇದೆ. After that, I have made representation for further investigation, which was not acted upon. Because of that, I have approached on.
And AG accepts notice for response. She seeks for and is granted 10 days time to obtain instruction, make a submission, relist on 9th December.
18, Rajeshwara PM.
Petitioner is a doctor. He has now been suspended by the Karnataka Medical Council. Appeal is filed before the Ethics Committee of the National Medical Council on 6/11, my lords. Till date, even after filing a memo on 14/11, our date is not fixed. The suspension order will come into effect from 30th November, my lords.
Who appears for respondent number 3?
That's Mr. N. Ketty, my lords.
Get him, please.
Please.
Aso.
Great.
19,
Lord, 19, I will take notice for respondent number 124, my lord. He filed a representation to consider, my lord. That one child was died in school, my lord. They given a representation to take action. Take an investigation.
And AG accepts notice for respondent number
124, R5 school.
Private school.
Oh, is something.
Notice to respondent number 5 is dispensed with, since any action proposed to be taken would be in furtherance of inquiry to be conducted by respondent number 3 and 4.
Okay.
The petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the petitioner's second daughter expired on 31/7/2018 due to negligence of the 5th respondent institution. And in that background, representation had been submitted on 23/1/25. 23/1/25. 7 years.
There are two representations.
7 years admin.
Annexure
The death was in 2018, the representation is in 25.
That is page 54, my lord. That is 23/10/25 representations.
None appears for the learned AG accepts notice for respondent number 1 to 4. Notice to respondent number 5 is deferred for now. None appears for the petitioner. To give one more opportunity for the petitioner to be represented. Relist on 15th December.
20,
No, 20 is defreezing, my lord. I will take notice for
And AG
R1,
accepts
my lord.
notice
R2 is Canara Bank.
for respondent number 1.
R2 is Canara Bank.
Vinay Bhatt.
Vinay Bhatt for respondent number 2.
R3 is one Manjunatha private party.
My lord, this is a case, my lord, on the complaint. My lord, I'll just, my lord,
We
my lord,
are
a
only
lien
issuing
may be-
notice right now.
Please, my lord, a
Who is
lien may be
respondent number-
kept, my lord, for the moment. My lord, 5 lakhs is the amount which they claim. My lord, which is received by me. My lord, my lord, that let there be a lien on that amount and I may be permitted to operate the account.
Who is
I'm a farmer.
Who is respondent number 3?
My lord, he is the one who has given a complaint.
Where is the complaint?
My lord, complaint is at page 98, my lord, annexure C. And my lord, typed copy is at page 100. And 101, my lord, is the endorsement given by the police. My lord, he claims that this is a check for which he has already lodged a complaint in NCR 78, my lord, in 2019. My lord, that 103, my lord, I have produced the photocopy of the check. My lord, this is a check which is issued in 22.
5 ಲಕ್ಷ ರೂಪಾಯಿಗಳು 2 ಬಾರಿ ನನ್ನ ಖಾತೆಯಿಂದ ಹಣ ಅಂದ್ರೆ 10 lakhs.
10 lakhs by one Ramesh. My lord, this checks issued to Ramesh, my lord, is at page 103, my lord.
103.
If my lord would see on the top right, this is a check which is issued in 22. My lord, this could not be the check for which he would have given an earlier complaint.
This check has been issued in the year 25.
Please, but my lord, the check leaf
has been lost in 19.
No, that is why I said, my lord, may kindly have a look at the check leaf, or the top right end, my lord. My lord, the date of issue of the check. So this leaf itself is issued in 22.
Where do we get the date of issuance of the leaf?
My lord, on the top right, my lord, the extreme edge of the check, my lord.
That is the handwritten date.
No, my lord. It is a typed, my lord. The date of issue of the check, my lord, is mentioned, my lord. My lord, there is this Shri Secura Print Private Limited.
Which page are you
CTS
referring?
2000. My lord, 103, my lord, the check, my lord.
103.
My lord, the printer's name is printed, my lord. CTS 2010 check.
On the right hand side.
My lord, the extreme left on top, my lord.
Extreme left.
But the right side of the check. So, my lord, this check is issued, I think 2012-2022, my lord. Just above the printer's details. So, my lord, it could not have been a check which is lost in 19.
Mr. Naik, make a submission on that.
Please, my lord. So, my lord, a lien may be placed for that amount.
3 is deferred for now. Released on 2nd December. Serve a copy on it.
I would. Lord, till then, my lord, by keeping a lien, my lord, I may permitted to operate the account.
Let us find out what it is. AGI find out if there is any other lien. It's only this private complaint, one-to-one complaint, it's fine. If the cyber fraud issues.
I will take instruction whether it is.
And my lord, no FIR is registered on this.
25th, my lord, all matters.
25th,
please.
Serial number 21. Avinages.
Serial number 7 or the second.
So the same blacklisting order, my lord, without following 26A procedure.
Paso. We'll take it up together. Yes. Same tender. When is the evaluation?
No evaluation. This is for debarment and blacklisting.
Debarment. Then we'll take it up on Monday together, all 3 of them. Any other petitions, all of them tell us.
So all three have.
All 3 will take it up on Monday. 21. IA 1 or 25 is allowed, and an AGA accepts notice for the respondents. All of them.
I hope.
Connect with serial number 7. List 2. Any orders to be passed in that matter? No. Any housekeeping works, 7. And WP number? Relist on Monday.
They will not take any coercive steps against me.
From taking any coercive steps against the petitioner till the next day.
Great.
22.
Interim order and 7 may be extended. Interim order.
Mr. Dhyan Chinnappa did not pass the iPad now. Sorry, what is your submission?
So in serial number 7 and list 2, the interim order needs to be extended.
Extend. Interim order and serial number 7 extend.
But the government has issued circular as to when the police has to interfere in the civil matters.
Yes.
My case, PDO mutates the kata in my name and he himself lodges complaint to the police. Police is after me. Every day I have been called in the police station. Let them investigate the matter and file FIR, whatever.
PDO transferred the kata in your name.
He himself lodges a complaint saying that the kata is fabricated.
Earlier PDO or the same PDO?
Same PDO. The police, every day I am called in the police station, I have been made to sit. They don't even investigate and it is politically motivated. Annexure L is the complaint and kata, everything is muted by the same PDO.
Annexure L page
37.
What is the complaint about?
Complaint is nobody has lodged the complaint. PDO lodges a complaint saying
what is the allegation?
Allegation is that the kata is inserted and fabricated. He is the author of this document. I understand if earlier PDO has done it and it is noticed by the now present CDO. And I have produced the register extract showing the
court MS Devraja. Shri MS Devraj is directed to accept notice for respond number 1 and 2. And AGA accepts notice for respond number 3. Shri MS Devraj is directed to counsel for the petitioner to furnish 2 sets of the petition along with annexures on the said counsels. Shri MS Devraj is directed to secure instruction, make a submission as to why the complaint at annexure L dated 18/9/2025 came to be lodged. Respondents are restrained from taking any steps to cancel any records, any official records in the name of the petitioner till the next date of hearing.
Previous matter could be at 2:30 minutes. It's only a short matter. At 2:30. I'm so sorry.
2:30. No, 2:30 Monday we have all the parole matters. So this Monday, this Monday is 25th Alado.
25th.
25th. Okay, 24th is fine.
23. Mamata PG.
Petition, my colleague kidney stone formation.
Mike is that side.
Kidney store formation agi operation agide. Next week any date, my lord, please.
Consider the representation. And what is the representation? Not to remove 1,250 cards. And AGA accepts notice for respond number 1, 2, 3 at the request of counsel for the petitioner released on 11th December.
24.
That Janoswadi matter, my lord.
I1 of 25 is allowed, I2 of 25 is allowed. Same order.
Same order, hospital ಹೆಸರು change ಆಗಬೇಕು. Connect with 33510 of
When is it?
On 12th of December.
12th December.
The name of the hospital will have to be changed.
Yes.
I've given it.
Hospital petitioners.
Great.
25.
Before the petitioner's counsel. Well, a petitioner before your lordships operates a mini hydel power project. And he's operating, the company is operating for the past 20 years. The lease granted by the forest department is expiring on the 24th of November, which is on Monday, my lord. On 5th of November, we receive a communication from the forest department. While you have made your application, you cannot continue to operate from.
Asking for consideration of your renewal application.
Please, my lord, please.
Who has to consider it?
My lord, it is the respondent number 5.
5.
Deputy Conservator of Forest. It is pending before him because I have already applied under
And
Parvesh.
AGA accepts notice for respond number 1 to 5. Who is, 3 is Center Ministry of Environment or State?
It is state, my lord. Kendriya Sadhana, which is in
Kendriya
Koramangala.
Sadhana antike kelid.
Kendriya
Kendriya Sadhana is all the central government.
Because it will have to go through the process of stage 1, my lord.
Respond number 3 is central government authority or state government authority?
Central government. They have their office. in
AGA for 1, 2, 4 and 5. So Shanti Bhushan is directed to, DSGI is directed to accept notice for respond number 3. The short grievance, the petitioner is before this court seeking for the following reliefs. The short grievance of the petitioner is that the renewal application which had been submitted by the petitioner on 27/12 2024 is yet to be considered by respond number
5, my lord. Point number 5.
5. Whenever any application for renewal is submitted, it is required for the concerned authority to consider the application and pass necessary orders within a reasonable period of time, either accepting or rejecting the said application. Needless to say, if the renewal application were to be rejected, it would have to be accompanied by reasons. Admittedly, the application having been filed on 27/12/2024 is still pending consideration. Hence, the respondents are respond number 5 is directed to consider the said application and pass necessary orders within
3 weeks.
3 weeks from within 21 days from date of receipt of a copy of this order. It's made clear that this court has not expressed any opinion on the entitlement of the petitioner for the renewal.
My lord, we may be permitted to continue to operate until my application is considered, because
But
24th.
needless
it
to
will
say, until orders are passed on the renewal application, the petitioner would have to be permitted to continue to operate the mini idle project till that date.
Obliged.
26, GS Venkata Subbarao.
My request kindly pass over, my lord, is, my request to kindly pass over this matter, my lord, on behalf of the council on record is on the way.
Pass or rather unlikely to reach Adhikar.
Kindly,
Notice is to be issued, is it? Rera, you are the developer.
my lord, I am on behalf of the petitioner council is held up in traffic.
And AG accepts notice for respond number 1. Shri Rajshekhar K is directed to accept notice for respond number 2. You are appearing for whom, madam?
The serial number 26, respondent 3 and 4, madam.
3 and 4. What about 5? Pratibha A. Purushottam, wife of Purushottam.
The landowner, I am the abutter.
Ms. Nikita Adinarayan submit that she will be appearing for respond number 3 and 4. Notice to respond number 5 is deferred for now at the request of counsel for the petition released on Monday.
Tomorrow, my lord, ನಾಳೆ ಅಲ್ಲಿ ರೇರ ಇದೆ ಅಂತ
Tomorrow
ಅಲ್ಲಿ.
is CMP day, ನಾಳೆ ಆಗಲ್ಲ.
27,
Same order. Up to 30 same. 26, 30 same, connect to each other. With each other.
31, Kumar JC.
In this case, make submission. Lord, I'm sending the notice to the petitioner, my lord, they are not cooperated. Therefore, I'm from the case, my lord.
Retired and dismissed, that's it.
After some interim order modification, my lord, they are not contacted, my lord. Quite of my best effort, my lord. I have also sent the notice, my lord.
Petitioner is before this court, could you memo? Petitioner is before this court seeking for the following relief. An interim order having been granted earlier. Time and time again, the response have been insisting for the matter to be taken up for hearing.
It was modified, my lords.
When the petitioner, when the petitioner was called upon to address arguments, adjournments had been sought for on the ground that instructions are required. Today, a memo has been filed by the counsel for the petitioner which reads as under. Along with the said memo, a letter dated 7/11/2025 addressed by the petitioner, addressed to the, by the counsel for the petitioner to the petitioners has been produced. The said letters have been returned with the endorsement, no such person and or insufficient address. Learned counsel for the petitioner today submits that without instruction is unable to argue the matter and has said request for permission to retire from the above matter. In view of the retirement memo which has been filed and the reasons stated therein, the counsel for the petitioner is permitted to retire from the matter, is discharged from the matter. There being no other representation made on behalf of the respondent and the letters issued by the council itself and in return with the endorsement.
No representation on behalf of petitioners.
Petitioner.
Respondent.
Sorry, petitioners.
ನಾವಿದೀವಿ ಅದಕ್ಕೆ ಸ್ವಾಮಿ.
I am here. My una. No arrangements having made for representation of the petitioners, there being no purpose served by issuing court notice, since the notice issued by the counsel for the petitioner has been returned with the endorsement. No such person stroke insufficient address. I am the consistent opinion that there would be no purpose in continuing with the above matter. Petition stands dismissed for non-prosecution pending IA stand disposed.
32.
The petitioner, my lords, may I seek for a pass over, my lord. Senior is on his legs, my lords.
Unlikely to reach if it is passed over.
Tomorrow, my lords. Monday.
Be free.
Yes.
Relist on 25th. 25th.
Grateful.
33.
May it please, Millets. Millets, I beg to appear, Millets, in item 33.
Yes, madam, you appear for whom?
Millets, I appear for the petitioner in item 33, Millets.
Petitioner. Who appears for the respondents?
I appear for arrows, R5 minute. Respond number 5 minute.
You appear for R5. R5 to 10.
No, R5 minute I appear for R5.
Cyril Prasad Paras has appeared for 5 to 10.
Has filed a caveat for that. R5 is the company minute insofar as company is concerned. For the individual directors, not will let it friend.
M.N. Kumar for 1 to 4.
1 to 4.
Yes. 5 is the company, 6 to 10 are individual directors. And they are represented by, the caveat has been filed by Mr. Pius for them.
But thereafter, I
And
think.
Vandana PL has also filed caveat for 6. Who are you appearing?
Lord, I would appear, my lord, for 6, 7, 8, and 9. 10, my lord, my senior Jaikumar sir appears.
Who are the advocates on record who will appear? First tell us
I
that.
filed wakalat for R5, my lord. Caveat do I file for all respondents?
You appear only now for R5.
R5.
6 to 9, Vandana PL.
Vandana PL.
10, who is the advocate on record? No advocate on record under Jaikumar Patil are appearing. Mr. Patil, who is your advocate on record?
Tahir is there.
Tahir is there.
Mohammed Tahir is there.
Who has filed wakalatnama?
I undertake to file wakalat.
Undertake.
On behalf of Tahir, my lord.
Registry is correct the appearance of the counsels for the respondents as Mr. Cyril Prasad Pius appearing for respond number 5, Ms. Vandana PL as that appearing for respond number 6 to 9. She so and so undertakes to appear for respond number 10. Yes. Yes, madam.
Please, Millets. Millets, there is a small,
There is some office objection. What is the office objection?
Millets notice has been issued, Millets office objections have been cured. There is an amendment, Millets, that we had filed for the prayer on the 21st of August 2025, Millets, for Millets just amending prayer number 1.
It's not cleared. Orders have not been passed. The Caveta councils confirm receipt of a copy of the petition.
Petition
along
not,
with
but
annexures.
no amendment not we are not.
We have already served, Millets, that was served 3
Office
months.
objection does not survive for consideration. We have other 2 office objections. Annexures, prayer to be stated correctly, cost titles.
Millets, all that have been cured already, Millets. And that was waived off, Millets, on the last time, and that was Millets notice was issued.
I don't think notice is issued, my lord.
Notice is issued, Millets, your lordship may please.
This has not been ordered, madam. Only M.N. Kumar had undertaken to.
I'm so sorry, Millets.
Nobody else, and your office objections have also not complied. Please comply with them.
Please, Millets.
Please. You have filed amendment application.
Please, Millets.
That counsel for the petition submit that she has filed amendment application. Registry is direct. You have not received copies. Serve a copy.
Served, Millets, on Miss Vandana and Millets, Mr. Pius 3 months ago, but I'll reserve it.
You will not an extra copy.
Please sort out all these things. The respective counsels for amendment applications will file registries direct put up the same. The respective counsels for the respondent seek for and are granted 2 weeks time to file the respective objections to the petition, the main petition as also the amendment application. Objections, if any, to be filed on or before 4th, failing which it will be taken as not filed and matter proceeded with, released on 11th December.
Only one submission which I would wish to make. Your Lordship,
3 weeks.
please, my Lord, annexure A, page number 91.
3 weeks.
You want to argue?
ಇಲ್ಲ ಒಂದು already petition ತಮ್ಮ ಮುಂದೆ ಇದೆ. My lords may kindly recall, we wanted to withdraw the petition and your lordships, my lord, said yes, go ahead. Then my lord, they said no, we will not allow the withdrawal. That is, my lord, annexure A. In the teeth of that, my lord, I was wondering if it could be clubbed with that.
Whatever pending matters are there, you tell us, we'll club it.
Please, Millards, in fact, Millards, what has happened in this matter is, Millards, that there was an ROC order which said that the appointment of respondent number 6 to 10 is defective. And despite then, Millards, that order was challenged by them before this honorable court. There was an interim order obtained to not take any precipitative action against ROC. Then, Millards, when we pushed for this matter to be heard after it was kept in abeyance for 6 months, they said we are withdrawing the petition because now we have cured the objection. And Millards, this is exactly, Millards, why we had to file this writ petition is, Millards, because after they made this submission in the other connected matters, that they have filed some new forms with ROC, and I'm the complainant before ROC, Millards, because they have removed me forging my signatures, and the FIRs for forgery are pending. So, Millards, in that case, Millards, ROC has given an answer to me saying that I cannot share the forms with you which they have filed, even though I'm the complainant before ROC. Millards, that's why my interim prayer was that, Millards,
Your prayer is that they should not accept any documents filed by respondent number 6 to 10.
Please, Millards. And
So
Millards,
long
and
as
that
they continue to be
They have gone to
directors.
NCLT, not
Millards,
NCLT.
Millards, exactly. If your lordship
You
may
will
see,
not trouble your lordship at this stage by saying all
ROC
that.
itself, Millards, has passed a detailed speaking order saying that their very entry into the company is defective. And that is the order that they had challenged before this honorable court. And Millards, now they are conceding, saying that we will cure
They
the
have
defect.
challenged that in another matter, which is
Yes,
that.
please, Millards. Millards,
What
that
is
is
the
writ
number?
petition number 50303 of 2019, GMRES, Millards. And Millards, connected with
50303.
of 2019, Millards. Connected with, Millards, 50317 of 2019,
Yes.
50322 of 2019, Millards. And Millards, writ petition 3520 of 2022, Millards. Millards, in these petitions, Millards, they first challenged the ROC's Millards order marking their entry into the company as
How
defective.
many litigations are pending now before this court?
Only 2 line submissions.
This matter, only these.
Only this.
Oh, Millards, this is one stream and then the other is the criminal FIR.
Therefore, of course, not, there are different matters which will not trouble your lordship at this stage. But
There are a lot of tributaries.
That will not trouble your lordships on the tributary.
Today we will not.
Not today. Connect with WP 503003 of 2019, 50317 of 2019,
It's page number 50.
50322 of 2019, 3520 of 2022. We consider all of it one. Pleadings are complete. 3 weeks.
3 weeks.
3 weeks. Objections, then it will be after vacation.
Please.
Objections, if any, by 18th December, released on 2nd week January.
Please.
13th January.
Great news.
ಇದು connected.
In the meanwhile, office objections to be complied with.
34th. Mr. Kumar.
Petitioner, my lords. I sought for stay of annexure B, my lords, wherein respondent number 4 restrain the petitioner from participating in the festivals of the respondent number 4 temple. Annexure B 22, my lords. He has challenged this notice before respondent number 1, Commissioner, my lords, that appeal came to be dismissed on the ground that there is a criminal case pending against the petitioner. My lords,
Order has been passed by?
Administrator of the respondent number 4 temple. This was notice.
Yes.
My lord, in this kindly see para number 4, my lord.
Ready?
No, my lord, I have to file objections in this.
My lords,
I have to file objections in
When
this.
will you file?
Week's time may be granted.
My lords, I
The
sought for
DGA seeks for and is granted a week's time to file a statement of objection. Objections, if any, by 3rd December If not filed by then, it will be taken as not filed, matter proceeded with, relist on 9th December.
Sought for
Yes, my lord.
interim prayer, my lord, in
It
respect
is
of,
here, dismissal order has been passed, we will have to consider
Yes, my lord.
oh, in preliminary hearing, my lord.
in preliminary hearing.
Please.
That you can request.
Yes, my lord.
35, HC Shivramu,
35.
connected matter.
You received copy, madam? You received copy?
No. Writ petition copy is with me. If you filed any IA, it's not with me.
Writ petition copy have you received?
No
yes, are filed so far. No, it was adjourned on the thing to say that my learned senior friend said that he has a citation which will enable him to convince.
Just
Sorry,
housekeeping.
I'm so sorry.
Learned counsel, for the cavator confirmed receipt of a copy of the writ petition along with annexures, hence the office objection does not survive for consideration in respect thereof. What is the other office objection?
In my case, there are.
R3 and 4 by name made party. Who are these?
ಅವರಿಗೇನು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡ್ಬೇಕಂತ ಕೊಟ್ರ ಇನ್ನೊಂದು ಸೆಟ್
You removed the names.
ಮೂರಿಲ್ವಾ
And counsel for the petitioner submit that subsequent to the office objection having been raised, the names of the respondent number 3 and 4 have been deleted and only their designation has been retained. Hence, office objection at sale number 1 also does not arise for survive for consideration. 35.1 IA 1 or 25 is allowed. There is a impleading application filed in 35.1.
Your lordship has already passed an
Lord's,
order.
Your Lordship's
You can-
peruse order 11/11/2025.
IA 2 of 25 has already been disposed. Registry to take note. Yes. Yes, Mr. Rajgopal.
There are petitioner, my lord. My lord, the impugned order is at page, annexure G, page 42. Where, my lord, the administrator was appointed under section 27, capital A. Page 42, my lord.
Yes.
That the only reason assigned is, my lord, election is not conducted within stipulated time. The board was, governing council was elected, assumed the charge on 22/10/2022.
You had to give us a decision or
Correct.
something.
That's
as
my lord, I
regard the
have got the
calculation of the year.
full judgment of our high court. That is, my lord, your lordship may kind. What is meant by year and other things, my lord, dealing with Cooperative Societies Act. My lord, it is Karnataka Cooperative Societies Act.
Yes.
May I request your lordship to go to
You want a
paragraph?
copy to the other side?
Yes, we have given to government advocate.
Yes. Yes, please.
My lord, paragraph 14, Patide Alaka. Judgment copy. My lord, paragraph 14, my lord,
Student ಗೆ correct ಆಗಿ ಕೇಳ್ಬಿಡು.
I tried him such a way.
Notes ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ exam ಬರೆಯೋದು ಕಷ್ಟ ಆಗುತ್ತೆ. 14.
Para 13 is the submissions, my lord.
Yes.
Para 14 is the consideration of those submissions. Para 14, I can take your lordship, my lord.
Yes, please.
Having given our anxious consideration to the rival contentions, we find that in the light of the clear language of subsection 4 of section 28 capital A, it is not possible to accept the contentions of the learned counsel for the respondent that term year as employed by subsection 4 must have the same meaning as the term cooperative year employed by subsection 3. When the legislature is one of the subsection uses the term cooperative year for denoting the term of the managing committee, advisedly used the term every year in subsection 4 while dealing with the elections of office bearers of the society to be elected from among the members of the managing committee. It becomes obvious that term of the office bearers are linked up with the actual year, not with the cooperative year. It is true, explanation to subsection 3 starts by saying that it is for the purpose of section, but the remaining part of explanation clearly indicates the limited field on which it operates, namely for the purpose of computing the term of the office of the committee. It cannot be projected any further, any process of interpretation, as would amount to legislating on the topic. It is also to be kept in view that the term year is not defined by the Act. Hence, we can certainly fall back upon the provisions of Karnataka General Process Act, Section 3, subsection 43 of the Act. Defines the term. Year means a year reckoned according to the British calendar. That means 12 months computed according to the British calendar. There is nothing in the Act which makes this meaning of the term year repugnant to the context for delimiting the term of the elected office bearers. This result also flows from the express language of subsection 3 of section 4 of section 28 capital A. Reconciling the two provisions, it becomes obvious that once a managing committee has been elected, its life will be 3 cooperative years only. But within the span of life, the managing committee every year is called upon by such subsection 4 of section 28 capital A to elect the office bearers, including the president among its members. It is, of course, true that while undertaking such yearly exercise for election of the office bearers, from amongst the members of managing committee may find that lost body of the elected office bearers may not get the full span of 12 months. Life as the managing committee's own term may become to an end by the end of the 3rd cooperative year. But that would happen not because subsection 4 of section 28 capital A of the Act, but because of the fact present body itself ceases to exist at the end of the 3rd cooperative year, taking with it office bearers elected from among its own members who have to vacate their office as managing committee members at the end of the 3rd cooperative year. Reliance placed by the learned counsel for the respondent on section 29 capital A of the Act also to avail, as that refers to commencement of the term of the office of the managing committee. That was nothing to do with the term office of the elected office bearer from among us the members of the managing committee, as laid down by subsection 4 of section 28 capital A. Learned counsel for the respondent number 3 had also placed a strong reliance on section 63, especially subsection 4 capital A thereof. Even this provision is of no avail to the respondent for resolving the present controversy, for the simple reason that audit, inquiry, inspection, surcharge accounts have to be made up for each cooperative year. Therefore, the statement showing the receipt and disbursement to profit and loss of the balance sheet would naturally refer to that cooperative year. The term year as employed in the latter part of subsection 4 capital A section 63 must necessarily take color from the term each cooperative year as employed in the beginning of the subsection. Such is not the case where subsection 4 of section 28 capital A, which covers entirely a different field, independent of the field covered by subsection 3 of section 28 capital A. Reliance placed by section 27 of the Act is also no avail for deciding the present question at all. The mandate is annual general meeting of a cooperative society has to be held once in a year. That year has nothing to do with the term of the office bearers of a cooperative society that ought to be elected as per section 28 capital A4. A faint attempt was also made by the learned counsel for the respondent number 3 to rely upon the bylaws of the society to indicate a different intention. But it is well settled that bylaws cannot cut across the mandatory scope of the section. Hence, this attempt was also futile attempt of recapture. Subsection 4 of section 28 capital A endorsed the members of the managing committee, elect from among themselves the officers of the cooperative society every year. It thus implicitly prescribes the term of the earlier elected body or office bearer to be 1 year, while subsection 3 of 28A deals with the term of office of the managing committee itself, which is laid down to be 3 cooperative years. Thus, both these provisions deal with different topics and are enacted for catering to the requirement of a different fact situation. It is true that subsection 4 of section 28 capital A nowhere expressly provide for term of office of the cooperative society, etc. Then, my lord, this is further laid down. Ultimately, why I am referring to it, your lordships may kindly see, my lord, definition of the year under the Act itself.
Cooperative society, security society.
Section 2, clause F, my lord.
Yes.
The year means the year ending on 31st December, or in case of any society or a class of societies, the accounts of which are made up to any other date which previous sanction register, year ending with such. This is the definition of the year. Then, my lord, the term of the office bearers are not specified in the act itself. It is not specified. Term is specified under the bylaw of the society.
Yes.
Your lordship may kindly go to the bylaw for a moment. Bylaw is page 48, annexure K.
48.
48, annexure K. Relevant is page 50. Clause 6 of the bylaw at the bottom, my lord. Page 50, bottom, my lord. Last line of page 50.
50 is the beginning of annexure K.
I think, my lord, some pagination mistakes. Clause 6 may kindly be seen, my lord.
Clause 6.
Yes. 5 is the jurisdiction 6.
The year of the association.
Yes, year of the association shall be the financial year.
Page 52. Yes.
Then, my lord, term of office is specified under, my lord, page 50.
Clause AD.
58, my lord.
Give us the clause because numbers are not correct.
Yes, clause 12, my lord.
Clause 12. Page 60.
Correct.
Term of the CEC is.
The term of the CEC, Central Executive Committee, ZEC, zonal, etc., shall be for a period of 3 years. They will continue to hold the office till now. Committee is elected in their place.
New committees.
My lord, years does not prefixed with the financial year. Therefore, year employed in clause 12 is nothing to do with the year employed under clause 6 of the bylaw of the society. This is precisely the point considered by the full bench dealing with Karnataka Cooperative Societies Act. Therefore, my lord, this term.
When period of 3 years.
3 years, it is a one clause. Then they can continue till hold the election. 2 clauses are there. If for any reason board could not able to continue, then after expiry, even after expiry of the term, the board could not able to continue for various reasons, then appointment of administrator is permissible. Suppose board could able to continue, then later part of the clause 12 of the bylaw would comes into picture.
The later part of clause 12 is contrary to section 27A1B.
Well, at 27A, well, at 20, that's what I wanted to say. Wow, Societies Registration Act does not specify the term of the office as in Cooperative Societies Act.
By the act.
By the act. Therefore, act does not indicate what the term of the office bearers of the governing council of a society.
Yes.
Term is specified under clause 12. Clause 12 consisting 2 components. One is 3 years is a regular period. Remaining period till they elect a new body.
So if the existing committee does not hold election.
That's a different aspect. What I am submitting is you hear is that situation is not there.
Consequence is that.
That's I do agree. I will. Well, what happens in our case? In our case, what happens is previously a notice was issued to us. We indicated that certain things are to be completed. Therefore, we require some more time to conduct the election. Then that request we sent it to the registrar. Later on, my lord, again they sent a letter to us. You have to conduct the election within 7 days, like that. Then we said, no, it's 7 days. It is not possible for these reasons. We have established our own calendar. Election will be conducted on the 5th January 2025. This is the assurance we have given. Now the question would be, the document is also produced. Question would be, my lord, the registrar, while submitting a report, he rejected that request without any reason. That report may not accepted by the government. Now the two things to be analyzed by your lordships in this matter is, what is the scope and jurisdiction of the power of the registrar send a report? What is the later part of decision taking process of the government? These 2 components are there. My first part of the component is, registrar had to submit a report which inclusive of the statement or objections or request, whatever we may, that also to be accompanied in the report. While considering the report, government has to take a decision This is precisely the reason I won't accept your request. Therefore, I am appointing an administrator. That is not forthcoming in the impugned order. May I kindly see the order for a moment.
Which statute provides for that explanation to be given first, and two, for it to be considered?
Beg your lordship.
Which statute, which provision
My lord,
provides?
section 27 capital A itself says so.
Does not appear to be so.
Section 27 capital A may kindly be seen, my lord. Can I read it?
Yes, please.
Notwithstanding anything in this act,
Hmm.
where any society on account of pendency of litigation or otherwise has not held or is unable to hold annual general meeting. May kindly see the language. Otherwise has not held or unable to hold the annual general meeting.
That is for the AGM.
Yes, 1 minute. Then the term of the office of the members of the governing body of a society are expired, and a new governing body has not for any reason been constituted. Third, C, where on a report made by the registrar, on a report consisting of subsection 1, class A, class B.
So their contention is it comes under B, not A or C. See, B does
No,
not
no.
provide for. A
B-
provides for the
My lord,
discretion.
A, B.
Provides for the discretion.
My lord, A and B cannot be read isolation. It can be read cumulative with class C, A, B, C to be read. Why A, B is necessary is,
Or, and Mr. Rajgopal, it's all disjunctive or for all of them. A, so and so, or not holding, or B, not constituting, or report made by a registrar.
correct. A report made by the registrar in related to the contingency covered under class A and B. C does not have any independent enabling provision. C is a running provision in context with class A and B.
That is
C
what we
is not an independent
pointed
provision.
out, that official gazette, comma, appoint should be the next line. It
Correct.
will be continuation.
When appointment is, where on a report made by the registrar, I would like to put it in this way, Milo. If the elections are not held, or if he could not be able to hold the election, government cannot directly intervene under section 27 capital A. It requires a report from the registrar. The enabling provision to submit a report to the registrar provided under class C. Without there being a report by the registrar, the contingencies covered either under A or B could not be given effect to.
Is your submission.
It's my submission. I can take support from the judgment of our High Court in that context.
For even A and B, a report is
Yes,
required.
A and B.
If there's a judgment, please give us.
Yes, my lord, your lordships may kindly see. Arvind Kumar judgment ಇದೆ ನೆನ್ನೆ ರಾತ್ರಿ ತೆಗೆದೆ 2005 KLG. Yes. ತೆಗೆದಿ 2016 2 KLG. ಈ ಕಡೆ ಬನ್ನಿ, ಅವ್ರು ತೆಗಿತಾರೆ. You come here. You come that side. 2016 2 KLJ 508 ಇಲ್ಲಿದೆ ತಗೊಳ್ಳಿ. ಅವರಿಗಂತ
Yes.
At paragraph 5, I would like to take below. Third respondent has filed a statement of objection supporting the impugned order, contending inter alia that petitioners have no locus standi to file the writ petitions on account of complaint received against the fourth respondent association. It had committed serious acts or omission. On commission, on enquiry came to be initiated. It was found in enquiry there was been non-compliance of mandatory provision under section 11, 12 and 13 of the Act. As such, there was no need for issuing any notice to the fourth respondent association or to any other person prior to appointment of administrator. Well, this is the gist. It was a justification on the part of the other side. It is contended that subsequent to the enquiry report, and the recommendations of the appointing administrator by the communication director so and so, first respondent exercise the power vested under section 27 capital A of the Act as appointed an administrator. Therefore, it is clear clause A, B is in consonance with clause C to be read together, not isolation. Then paragraph 6 may kindly be seen. Perusal of the records would indicate that petitioner 1 and 2 are the joint secretaries of Fourth Respondent Association. Third petitioner is a member of the Fourth Respondent Association. He is also Vice President of Cocoa Federation of India, which is the parent body of the Fourth Respondent Association. Fifth respondent here is said to have been filed a complaint before so and so. Certain irregularities in working at the Fourth Respondent Association as per Annexure D. Based on the said complaint, third respondent initiated an inquiry, issued a notice to the Fourth Respondent Association. The headquarter assistant office of the district registrar Gandhinagar, Bengaluru, have been appointed as so and so. He made into the allegations made by the complainant. Third respondent issued a notice on so and so, Fourth Respondent Association. During the course of an inquiry, second petitioner has appeared on behalf of the Fourth Respondent Association, filed the copies of the balance sheet, statement of audited account, income and expenditure of association, also the list of members of the governing body, as was filed before so and so. Wide Annexure F. Inquiry officer on perusal of the record has submitted a report on 21/6/2014, Annexure G. Said inquiry officer who conducted an inquiry into the allegation made in the complaint has arrived at a conclusion that allegation made by the Fourth Respondent Association of not having submitted is not proved by the complainant. It is also complainant was fully aware of the audited balance sheet, income and expenditure account of the Fourth Respondent Association for the past 15 years. As such held, there was no materials to establish that there has been any infraction in conducting the affairs of the Fourth Respondent Association. Despite such finding, having been arrived at the inquiry officer, he has opined that the Fourth Respondent, namely association office bearers, have not been able to establish or prove that contents of the complaint is false. He has further opined that there is no material to show that association which was registered under the Karnataka Co-op Societies Registration Act as having been renewed from time to time. The delegatee of the third respondent has neither inquired into the requirement of annual renewal and respondent number for association, nor was called upon the fourth respondent to offer an explanation. Said report having been forwarded to the third respondent to the first respondent. First respondent intimated the second respondent, appointing fourth respondent, called upon the second respondent to submit a report in that regard by communication dated so and so. On account of alleged report submitted by the second respondent on 2/3/2015, first respondent impugned order dated 29/15, annexure appointing the administrator, the fourth respondent association came to be passed by first respondent. It requires to be noticed that this juncture itself is that inquiry came to be conducted by the delegate of the third respondent was based on a complaint given by the fifth respondent. Based on the said inquiry conducted in exercise of the power vested under section so and so, 1960 Act. G came to be submitted by the inquiry officer, who has clearly opined that contents of the complaint is far from truth. The other words, he has concluded that document from the fourth respondent association would clearly establish there is no merit, etc. Then, my lord, things are. Then para 8 may kindly be seen. Undisputably, the first respondent exercised the power under section 27 capital A of the Act to appoint an administrator, the fourth respondent association, based on the report of the inquiry officer so and so. Said report itself does not even remotely suggest that contents of the complaint has been proved, or in other words, complaint itself being meritless. Third words could not have been jumped to a conclusion. Association had obtained a renewal of its registration without any material available before it. As such, based on the said report, first respondent could not have passed the impugned order, that too without complying the principles of natural justice. After receipt of the report at Annexure D from the inquiry officer, third respondent, first respondent ought to have extended an opportunity fourth respondent association to reply to the said report only after hearing the fourth respondent of his office bearer, authorized representative, etc. This is the law.
Yes.
Now my submission is, may kindly see the inquiry order of the report of the registrar for a moment below.
Is that an inquiry under section 25?
No, no inquiry. No inquiry.
A report.
Only a report.
Yes.
Well, what happens was there is a fraction in our, so it is a fundamental origin. When an association takes breath, fraction automatically takes it's an invariable attachment. It's a two sides of the same coin. Some persons parallelly formed the society consisting of 85%. It was led by one Sudhakar Reddy. He was earlier our association president. Then, my lord, we have taken a decision to expel these 85% from the, because they registered a parallel association. Therefore, we passed a resolution by the working committee, then placed it before the general body. General body affirmed that resolution. Then, my lord, all these problems have started. Then, my lord, the inquiry, the registrar called upon to say when you are going to conduct the vote. My lord, file declared. We made a request that within 2 or 3 months, we are going to conduct the election without any failure. In the inquiry, in the file it is recorded, submission was accepted and agreed. That was the report signed by the registrar. Thereafter, what poked in between, we don't know. Then, well, this report was sent to the government.
Yes. What do you want to rely on in the report?
Your lordship may kindly the report at page 42, Milo.
Annexure?
Annexure G, page 42 in my page, Milo. I think there may be, it must be 44 according
44.
to me. Yes. My lord, I would like to take your lordship.
40.
10th line from the bottom of the first paragraph.
Yes.
ಆದರೆ ಸಂಘದ ಹಿಂದಿನ ಆಡಳಿತ ಮಂಡಳಿಯ ಅವಧಿಯು.
Annexure G is the gazette notification.
No, I think. File, which file is with your lordship? 33814, madam.
33814.
It is, this is according to my pagination, it is 42. Gazette notification is not here. Annexure G.
So this is the improved order.
Sir, correct. Alliro page gazette notification ತೋರಿಸ್ತಾ ಇದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಸಾಹೇಬ್ರು. This is the problem. Discrepancy is here.
That's the very same impugned order. Annexure G is referring. Is Annexure G gazetted?
Yes.
Only 10th line from the bottom of the first paragraph. ಆದರೆ ಸಂಘದ ಹಿಂದಿನ ಕುಡಿಯುವ ಲಾಶಿಸ್ ಮೇಲೆ ನೋಂದಣಿ ಕಾಯ್ದೆ ಕಲಂ ಸೋ ಪ್ರಕಾರ ಕ್ರಮವಿಡಲಾಗುವುದು ಎಂದು ತಿಳಿಸಲಾಗಿದೆ. ಆದರೆ ಸಂಘದ ಹಿಂದಿನ ಆಡಳಿತ ಮಂಡಳಿಯು ಅವಧಿಯು ದಿನಾಂಕ 11/10/25 ಕುಡಿಯುವ ಲಾಶಿಸ್ 11/10/25 ಮುಕ್ತಾಯಗೊಂಡಿದ್ದರೂ ಸಂಘದ ಚುನಾವಣೆ ನಡೆಸಲು ಚುನಾವಣಾ ವೇಳಾಪಟ್ಟಿಯನ್ನು ತಹಸೀಲ್ದಾರರಿಗೂ ಹೊರಡಿಸುವುದಿಲ್ಲವೆಂದು ಸಂಘಕ್ಕೆ ಚುನಾವಣೆ ನಡೆಸುವಂತೆ ಪದೇ ಪದೇ ದೂರು ಅರ್ಜಿಗಳು ಸ್ವೀಕೃತವಾಗಿ ತಿಳಿದಿರುತ್ತದೆ. ಮುಂದುವರೆದು ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿಯು ಚುನಾವಣೆ ನಡೆಸಲು 90 ದಿನಗಳ ಕಾಲಾವಕಾಶ ಕೋರಿ ಸಲ್ಲಿಸಿದ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಹ ತಿರಸ್ಕರಿಸಲಾಗಿರುತ್ತದೆ. May kindly note, it is rejected by the government or by the registrar, they have to explain. If the registrar has no power to reject it, because he has to only send a report to the government has to take a decision.
Yes.
Then, my lord, ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿ ಸಂಘಕ್ಕೆ ಕರ್ನಾಟಕ ಸಂಘಗಳ ನೋಂದಣಿ ಕಾಯ್ದೆ ಸೋ ರೀತ್ಯ ಆಡಳಿತಾಧಿಕಾರಿಯನ್ನು ನೇಮಿಸಿ ಅವರ ಸುಪರ್ದಿಯಲ್ಲಿ ಚುನಾವಣೆ ನಡೆಸುವುದು ಸೂಕ್ತವೆಂದು ಜಿಲ್ಲಾ ನೋಂದಣಾಧಿಕಾರಿಗಳು ಹಾಗೂ ಸಹಕಾರ ಸಂಘಗಳ ಉಪನಿಬಂಧಕರು ಮಾಡಿರುವ ಶಿಫಾರಸನ್ನು ಪರಿಗಣಿಸಿ ನೋಂದಣಿ ಅಧೀನ 27 ಪ್ರಕಾರ ನೇಮಿಸಿ. This is the order. Then followed with the operative portion of the order. Yes. My submission to lordship is this. Clause 12 of the bylaw I read. Invariably, a finding is required to be recorded even in the report. Why? Election board could not be able to conduct the election even after the expiry of the term, where bylaw provided or permitted to do that. If such reason is not there, question of invoking section 27 capital A does not arise. Merely because our term expires. As if in 28 capital A5 of the Cooperative Societies Act, your lordship is well aware, as well as me also.
Yes, please.
Where, my lord, to understand, elections are not taken place for expiry of the term. This is a deemed provision, administrator deemed to have been taken over the chart. But that was not the provision here. Act does not indicate terms of the term of the office. Bylaw provides. Their bylaw further component is there. It would be extended till next election is conducted. Your lordship put me a question. It's a question where a bona fide required to be shown by the management which is before the court. That's the reason, my lord. Your lordship put me a question, if you are not going to conduct, what happens? Virtually, it's a good question. But that is the reason, if I want to oppose this impugned order, on the ground that I have got a remedy because of later class 12 of the bylaw, invariably I should go show my bona fides. I should go but my lord, in the report itself it is said, we made a request when the notice was issued to in the month of September. We made a submission, within 3 months we are going to complete the election process. Now 2 questions I would like to put for myself. It is my request, I put to them. It's a part of the record in the report of the registrar. This is the request made by the managing committee. That he put an end there. He has no authority to reject it. He rejected, therefore I wanted to appoint an administrator under section 27 capital A, appears to be not so. It is not the purpose of section 27 capital A also.
Yes.
This is my submission. My lord, on fact, my lord, some material I would like to. My lord, may kindly see page 17, annexure B, my lord. ಇಲ್ಲಿ page 19 ಇರ್ಬೇಕು ತಮ್ಮ ಫೈಲ್ ಅಲ್ಲಿ ಯಾಕಂತ page ಎಷ್ಟು
Annexure?
Annexure B, my lord.
Yes.
It is a 3/10/2025. This is in response to the notice dated 10/9/2025 at Annexure A. Where he directed he should conduct the election within so and so date. Then we said, there are some impediments to conduct the election. Impediments are categorized 1, 2, 3, 4, 5, and 6. This is one. After we submitted, one more instructions are given by the registrar, Annexure C. That is on 8/10/2025.
Your term was for 3 years.
Yes, term is 3 years. Then, my lord, he passed an order. May kindly go to page 25 or last part of the impugned order of the registrar. He directs us to do it in such a way. May I read it, my lord?
Yes.
Karnataka Vidyut Shakti Mandali ಇಂಜಿನಿಯರ್ಗಳ ಸಂಘ ಬೆಂಗಳೂರು ದೂರು ಅರ್ಜಿಯನ್ನು ಪುರಸ್ಕರಿಸಿದೆ. ಕರ್ನಾಟಕ ವಿದ್ಯುತ್ ಶಕ್ತಿ ಇಂಜಿನಿಯರ್ಗಳ ಸಂಘದ ಚುನಾವಣಾ ಬೈಲಾ ರೀತ್ಯ 7 ತಿಂಗಳ ಒಳಗಾಗಿ ಚುನಾವಣಾ ವೇಳಾಪಟ್ಟಿಯೊಂದಿಗೆ ಹೊರಡಿಸಲು ನಿರ್ದೇಶಿಸಿ ಸದರಿ ಚುನಾವಣೆ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಕಚೇರಿಯಿಂದ ಹೊರಡಿಸಿದ ಆದೇಶ ದಿನಾಂಕದಿಂದ 30 ದಿನ ಪೂರ್ಣಗೊಳಿಸಬೇಕಾಗಿ ಸೂಚಿಸಲಾಗಿದೆ. This is some restraint orders are passed against us. Don't employ the public fund, other things that restraint order. Then we read Annexure D, page 26. That is our reply to the said order. Annexure D, page 26, 17th October 2025.
Yes.
My lord, in which, my lord, we specified the calendar. Page 27 may kindly be seen.
Yes.
We said we want to publish the draft voters on 16/11/2025. Objections will be called on 30/11/2025. Scrutiny of the objections on 15/12/2025. Final electorate will be published on 16/12/2025. 5/1/2026, we are going to conduct election. Even we have venue is fixed. SRS Suvarna Mahotsav Pina Darige ತೀರ್ಮಾನಿಸಲಾಯಿತು. Then returning officer also appointed by us. Deputy Registrar of Cooperative Society 1 Sunanda was appointed as a returning officer. May kindly go to page 38. Sandhya, I'm sorry, not Sunanda. Miller, these materials, placing on reliance on that, the doubt what your lordships expressed, surely a bona fide doubt. that we wanted to screen off showing our bona fides. There would be no reason remains with the authorities at the government that we wanted to step over the matter with an anxiety to hold the office for uncertain period. We said, all right, you directed it to do it within 30 days. Not possible for 30 days because of ABCD reasons. We complete the election process on or before 5/1/2025. Schedule we have indicated what day, what date, what we are going to do, what is the next process, what is another process. All these stages we have specified. This was also before the government. This report, the India report, he rejected. My question for myself is, where is an authority for the registrar to reject?
Yes.
This is my submission, my lord.
And 60 years no.
I'm a reply. My friend wanted to say, this established about 60 years ago. This is the first time by appointing an administrator, a small block mole is impressed at the instance of the unhappy member who was eliminated from the association. This is the submission they wanted to submit. I accord it through my, on instructions of my.
Yes. Appearing
Just-
for whom, Mr. Ravi Shankar?
But
You are the intervener.
I'm the intervener, but the pleading is something else and what is argued before Lordships is something else. Can I just request your Lordships to kindly have a look at paragraph number 11?
There is one more petition
One more.
connected.
Yes.
This is the one.
Lord, our contention in this writ petition is that
You can have.
the financial year we have to complete. We were elected on 12/10.
So 31/3/20.
If financial year is taken, Lord, 31/3/26 is
Is your
the
content.
term we are entitled to continue. And
Mr.
till today, Lord,
Mr. Rajgopal was more reasonable than you.
two financial year we have already completed. Accounts were approved. Now the procedure that is followed in these societies is that Lord, the existing society after completing the term, Lord, has to get the accounts audited, place it before the general body. On the same day, Lord, election has to be held. That is the practice followed in this associations.
What do you have to show us to that? You are making a statement.
Please,
You are making a statement.
Yeah, that is the practice.
Or
Lord,
actually
we
you
are
are
following.
declaring it without any documents being placed on it.
But the accounts were audited, Lord, that I am having the accounts.
You're a 60-year-old society.
Yes, Lord.
For 60 years, you've been following like this, and you're
Lord,
just making a
in the
statement.
history of the society, Lord, the elections were never held, Lord, immediately after completion of the term.
So you've always been a defaulter.
Always, Lord, there were delay, Lord. In this case, Lord, bona fide delay is that, Lord, voters list was not yet completed. Notices were issued by registered post. Members, Lord, are, Lord, the working and retired. Lord, they are, Lord, residing throughout the state. Totally 6,800 persons are, as on today, on the roll, Lord. Out of them, Lord, we don't know how many of them, Lord, retired persons may not in existence. And new persons were enrolled.
Yes.
We have to prepare voters list. For that purpose, Lord, to get details, Lord, we have issued notices to the members. That copy of the notice, so far as I have received, Lord, is Annexure E. Register post by register post, it was sent. That was produced by my learned friend, Lord, to show the receipts for having sent the registered post. We are yet to receive, Lord, the response from the members, Lord. We have to prepare voters list for, and we issue, Lord, photo identity card, Lord. Without that, Lord, we cannot hold election.
Yes.
Now here is a case where, Lord, in all, there was total urgency, Lord. You will
So you are still in the process of enrolling members.
Yeah, please, Lord.
You are in the process of enrolling members.
1 year this.
Lord, we are not going to enroll, Lord. Court can put a restriction on us. We cannot, we are not going to add any new member, Lord. As on the day, as on today, whatever is there, Lord, in the members list, we will update it. That's all. We will not enroll any new persons, Lord. You will ask me kindly see, Lord, register post by letters are sent and Annexure C, you lordship may kindly see, my lord. He puts a restriction.
Annexure C in your petition or?
Same, Annexure C. Your lordship may kindly see, timeline fixed by him is that, my lord, within 7 days we have to issue calendar of events. And within 30 days we have to hold the election without there being voters list. It is highly impossible.
Yes.
Page 25. This is the timeline, my lord. Impossible to follow, my lord.
Yes.
My then, my lord, as submitted senior counsel, my lord, well, returning officer is already appointed, my lord. What is the hurry, my lord? The appoint administrator. Then in the impugned order, the order refers to not report of the registrar dated 28/10. Copy is not yet furnished to us, my lord, not even produced before this court.
28/10.
Yes, my lord. Impugned order.
Annexure G, yes.
Gazetted, taken charge.
ಅಲ್ಲಿ 28/10 ಅಂತ ಇದೆ.
Which provision entitles you to a copy of the report?
Please, my lord.
Under which provision or rule you are entitled to a copy of the report?
So, principles of natural justice, my lord. We wanted to know what is the contents of the report.
Yes.
Our according to our instructions, my lord, on the day, my lord, he issues notice initially. We have appeared and made a submission that, my lord, we are going to hold the election. He recorded that and closed the proceedings. Thereafter, my lord, political pressure was brought. All these things have been done.
See, their contention is on 27. We have already said that. Let us hear.
Lords, I just wanted to say this.
The dead persons, my lord.
You cannot argue. Senior counsel has argued.
ಅವ್ರ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಂಡೇ ಹೇಳ್ತಾ ಇದ್ದೇನೆ.
Our instruction, our
ಅವ್ರಿಗೆ ಹೇಳ್ತೀನಿ.
Not everybody.
Lords, I-
Mr. Upin had a separate
ಅಲ್ಲ,
petition.
ಈಗ ಕೊಟ್ಟರ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಸತ್ತೋದವ್ರು ಎಷ್ಟೋ ಜನದಿದೆ, ಇದು ಒಂದು ಅಂತ ತೋರ್ಸು.
Yes.
Lords, after 1976, the legislative schemes have been substantially amended. Not whether it's.
You cannot be the lead counsel. The state.
Lords, I just wanted to, only on the legal position,
You're
Lords,
only
under
the
27A.
intervener. You're only the intervener.
Very well.
Since my lord is a senior.
Only on the
wanted
legal
him to-
position of law,
Only on
now
that.
that your lordships have said he can.
He is appearing for the interview.
Yes, lords. There's two issues,
You have
lords.
to justify this action.
Yes, my lords, two issues, my lords. As and when we had raised this issue, my lords, they had given their objections, which was read over in detail, my lords.
Are you exercising powers under 27A1A, B or C?
No, my lords. All the three are to be, we come under B, but all the three are to be distinctly read, my lords, for this reason, my lords. As and when the question of 27A, my lords,
Yes.
as and when the question of appointment of an administrator would arise, the first contingency will be wherein, that's as per Annex 27(1)A, my lords, where a society on account of pendency of litigation or otherwise has not held or unable to hold an annual general body meeting, then the contingency of appointment of an administrator. The second contingency will be as per B, my lords, when the term of an office of the member of the governing body or the society has expired and a new governing body has not been constituted. The third would be where on a report on various allegations and otherwise by the registrar or otherwise on inquiry, the state government considers necessary in public interest to do so. This cannot be read in conjecture notes. It has to be independently read because these are the only three contingencies under which the administrator could be appointed. And here is a case where, as per the bylaws, after the expiry of the term, my lords, they would not hold the elections and we were forced to appoint an administrator. Now, let us assume a contingency, my lords, where if they say that by financial year end, that is in March 31st, if the thing has to end, my lords, every year, for example, my lords, we are in the month of November. The elections are to be conducted on 29th of November. The next, after 3 years, it would come to the stage where it will be held in December. After that, January. By virtue of that, they will get more than 8-10 months time to run the institution without there being an election held.
Automatic extension every year.
Automatic extension if they want to do that, my lords. As per the bylaws, as and when the term ends, they should hold an election. Insofar as the two judgments which my learned senior friend relied upon, the full court judgment as well as the other one. This was a case where, my lords,
Operative year could not be read into the definition of year. That's essentially.
learned friend is prompting me to say. Minutes, is paragraph number 15 minutes.
15 has been read.
Yes, the last 4 lines. Even otherwise, Lord should get it at page 2379. Even otherwise, it is easy to visualize that if such an interpretation is placed on subsection 4 of section 28, the given elected body or office bearers may continue for even more than 12 months. This is what I try to explain, Lords. The definition is 15. Yes, but if the definition is given for the financial year which is ending on March 31st, Lords, then would be a situation where every year they will get more and more number of years. That's the precise reason why the bylaws would indicate that it would be on the completion of the term of 3 years. So far as the other one more judgment which was relied upon, Lords,
Not consider the dichotomy.
this was a case where an enquiry was held, and whether that enquiry was the reason why the appointment to be done or not is discussed. Nowhere does it in this judgment would say that without holding an enquiry, if an administrator appointed, it is violative, is not indicated in this judgment. My submission is not. We have already adhered to the timeline which is indicative in page number 38 minutes annexure L in the petition number 331,814 minutes, page number 38 annexure L.
Annexure L.
L ಅಂತಿದೆ ನನ್ನ paper book ಅಲ್ಲಿ.
Annexure D 33814.
Note ಮಾಡಿ 33814.
Annexure D is, that is the returning officer being appointed.
No, my lord, this is the
Patrika
the calendar of
events
for the election minutes.
Annexure
L ಅಂತಿದೆ ಇದರಲ್ಲಿ page 38. Last but 2 pages, 3 pages, 2 pages.
Lords, in 33855, it is annexure J, page 45.
63. Annexure L is page 63.
ನನ್ನ paper book 33814 ಅಲ್ಲಿ page 38.
This is the calendar of events.
Yes, my lord. We have adhered to it, and we have also crossed serial number 6, and may I just pass this across, my lord. These are the nominations which we have received already. The only thing which now requires to be done is
polling.
Election to be conducted, polling to be done on 29th of November, my lord.
29th November.
Yes,
Yes, my lord, 29th.
all is booked. Voters are informed.
Yes.
So now they will come and participate. They will, polling will take place on 29th.
All of it is done.
Everything is done, my lord. Only the polling is.
Here nothing for us to do.
It's 1976.
All this process is done.
Evening 7 o'clock, administrator report. Next day calendar request. Voters meeting, not even repeat revise. There is a employees association. There are about 60,000 voters.
6,000.
Out of it, every year, some 5 or 6 or 10, 20, 25, they are going to the report. If they retire, they cease to be the member. Their names have to be eliminated. New induction will be there because of appointment and other.
Yes. Yes, Mr.
Lords, I just wanted to say this, Lords. Lords, and
Reply.
Lords, I just wanted to say this. Lords, the legislative wisdom in relation to all the statutes which regulates the private bodies of the kind. It may be a cooperative society. Lords, it may be the society. It may be a municipal body. Wherever the democratic process is adopted for the purpose of choosing an elected body, not the legislative wisdom consistently in all the statutes is fixing the term from the date of the election. This is number one. Now, peculiar to the present state of affairs, not the peculiar to the Societies Registration Act. Up to 1976, the law was that it is for them to conduct the elections. It was the governing body which was required to conduct the elections. If they don't conduct the elections, let us assume that period expires, then what should happen? There was a leverage under section 11 to extend it by a further period of 6 months. This is how it was managed. 76, the amendment came about by introducing section 27 capital A. Now the whole object was the office which expires the term of that period, if they don't take steps for the
Stop their
purposes
period.
of constituting the new body, their right to conduct the election is lost.
Stopgap arrangement was
That's
done
it.
by way of ordinance.
Now, that power stands automatically vested in the administrator for the purposes of conducting the elections. 27A4, my lords of the Act,
Yes. Yes, shall convene.
just convene the meeting and hold the elections for the constitution of the governing body. The whole object is to ensure that the elections will be conducted. Lords, there is no power in the body which has lost its duration or the term to say that we want to conduct. The statutory scheme, my lords, that is the reason why the Learned Senior Counsel was referring. The 28A4 as it then existed required that every year there is a requirement of conducting. That's what was considered, my lords, in the full bench judgment in 1993. Subsequently, 28A4, my lords, your lords will recollect, was stood amended, where it said that the moment there is an expiry, there is a...
So the amendment was in 76, the judgment is 93.
Lords, this is under the Cooperative Societies
Cooperative
Act,
Society.
which dealt with the cooperative year and the year.
A5.
Lords, ultimately the full bench said you cannot impute year to the you cannot impute the cooperative year for computation of the term. It is only the calendar year. So from this day till the end of 1 year or 3 years, as the case may be, that is to be computed. That's a judgment, my lords, which favors the interpretation that there is no way that a term can be extended beyond the period of 3 years. That is a calendar years, 3 calendar years. The only other question is they
Calendar
can't come
year
before the court
would
and
it
say,
become 31st December.
lords, they have admitted, my lords, if your lords were to see, the term is ended in WP number 33855 of 2025. Lords, the association writes a letter at annexure B, page 17. The president of the association writes a letter. The letter is in reference to the upcoming elections of our association, as the term of the current executive committee is set to expire on 12/10/2025. The first paragraph.
Yes.
Lords, then your lords will kindly see, I'll just point out, my lords. On 1710, at page number
There is
26.
a third interpretation. One is financial year, next financial year.
Yes, Lord, that is
One is same calendar year.
Yes.
The third interpretation is year from the date of elected.
Yes, that's the reason why I said the
Yes, sir.
legislative wisdom consistently is 3 years is from the date on which a person is elected, computed by the calendar year. So that is, it is not going by the financial years. If it is in January 1st, then it is the 31st of December. That's essentially how, my lords, the year has to be computed. Now they have understood it. It is not that they did not understand it in this sense. I can understand. Having understood it in this sense, they said that yes, it is expiring on 12/10/2025. Lords, therefore, my lords, my respectful submission is that the requirement of conducting an election during the tenure of the office bearers is within that period of 3 years if they want to exercise that right. The moment they cross that period of 3 years, the right to conduct the election is lost. My lords, yesterday, my lords, your lordships have already taken a view in one of the matters. I just requested, I was here, my lords, your lordships dictated one of the matters. While interpreting section 27A1B, your lordship said that it is automatic. There is no requirement of, because it is ultimately a question of who should hold the elections. Lords, an office bearers whose term is already expired, whose laxity is so writ large that they did not want to conduct the elections, will not be given the baton for the purpose of conducting the elections for the next year. So that's essentially, my lords, the wisdom. So therefore, my lords, my respectful submission is that they don't have powers to hold the election. Now to come before the court and say that we want to conduct the elections and we wanted the postponement, it impinges upon the scheme of the statute itself. 27 years stands violated if this is done. And this clauses in the bylaws, which says that you are required to continue till the next, this says come up for interpretation, which says that day-to-day affairs. Till a new body comes into existence, day-to-day affairs. But here, what happens is, if such clauses are there, I just wanted to say this, my lords. These are the bylaws which were inserted prior to 1976. Usually these kind of bylaws are there, which was approved prior to 1986, after 1976. After 76, if it is by inadvertence or otherwise, there may be. But usually such clauses are not there in the bylaws registered after 1976. The reason is that the moment there is an expiry of the term and the new body is not constituted, Lordships may kindly see the powers that can be exercised under 27A. The body ceases. Subsection 3.
That is on the appointment of an administrator.
Yes.
It's not automatic on the expiry of the term.
Lord, that's the
It is
reason.
on the
Expiry
appointment
of
of
the
an
term, Lords, now on expiry of the term and the new body having not come into
You are
existence,
saying it's automatic on the expiry.
the reason
Therefore,
is,
3 will be automatic.
Lords, the reason is 27A1B requires that the moment the term is not, the term is concluded and the new body does not come into existence, they cannot conduct the elections. This is number one, because that power goes. Then it has to be done only by the administrator. Administrator has to be appointed under section 27A. There may not be a deeming provision, but in the scheme of the statute, it is like a formality that this has to happen only in this fashion. There is no other means by virtue of which the statute provides. There is no provision of law which they can refer to saying that if the body does not conduct the election within the term which is stipulated and the term expires, new body is constituted, there is a power vested in the government or any other authority constituted under the act which can extend this time. If this can't be done, essentially, the statute puts the embargo on the manner in which these elections are required to be conducted. In which event, the essential consequence will be subsection 3. So such bylaws which were registered way back in because it's a 60-year-old society, apparently it is prior to 1976. So these kind of bylaws will have to yield to subsection 3 of section 27A. No board can say that we want to continue for even a single day after the term is over if the new body is not constituted. Of course, this may be because this stopgap would have to be required only in the event the administrator may not have been appointed. But otherwise, my lords, the mandate is only this. This is how, my lords, the legislative wisdom has been throughout the country and throughout the state in respect of all democratic bodies. There is no way a person will be permitted to occupy the chair for which he is elected for the given term, because the election takes place for the given term. Beyond the term. For that given term, if he is elected,
Yes,
you have no right to be elected beyond that term. There's one judgment, my lord, sir, now I am recollecting, which said that a person.
243U.
Yes, my lords, no, under the Societies Registration Act itself, with reference to our association, my lords, that is Advocates Association, I think His Lordship Justice Krishna Dikshit has taken the view. The election takes place for a term.
Correct.
So the moment the term expires, the mandate given by the voter to you expires. You will not be extended. The term will not get extended because you are elected for the term. Lords, I'll just take that judgment, Lords. I had appeared in that matter. So
Mandate given.
the mandate of the electorate
That's the
is
next
for the term that expires. You cannot come and say that, no, you give me another one day also. That's essentially, my lords, what I'll just. So therefore, my lords, so grateful. Can I just seek your lordship's excuse, my lords? Sorry, my lords. So sorry, my lords.
Yes.
Going to the level, there are no diversities of associations or cooperative society. We are under parameter cooperative society. Very conscious. Society registration act is enacted later than the cooperative society. If the legislators intending to incorporate a term copy, they would have been got experience in the drafting of the cooperative society act. They teach it and that it is their experience start there.
Yes.
Societies and society registration in the Societies Legislative Act, so far as the office bearers are concerned, in par with the Karnataka Cooperative Society Act. But I would like to put a small example. Cricket Association is there. Suppose that the mark is the present board expert.
That is there in the afternoon today.
What happens, madam? There are international and going on in India during one. For so many reasons, that network could not be able to convey the election. It doesn't mean that government can go into much because 27A was drafted in such a way. Wonderfully it is done. It is not blanket. Report, inquiry, everything is there. Therefore, two legislations are filed in a contemporaneous period. One legislation says something, otherwise locally third. Other does not speak anything about that. It indicates there is a special reason behind that. But however, a part of that, it would no period is period. It's arbitrary what other things, dictators or person holding a cave, he never wants to go out from the cave. If it is permissible, he could sit there even after his office leave. That is the intention of the human being. That is the reason they say. We can fix that level. In a contract between the members and the club. Bylaw is a contract between the members and the club. Term is specified in the bylaw. In the very bylaw they said, you can continue because election should be pending at your control. What is it? That is the reason. Bona fide of the person who act in the office to be taken note of. Why period is not specified in the statute also to be taken note of. Why it is not with the cooperative society also to be taken note of. This is one aspect. That is the reason. There are several kinds of association which should not be universally regulated in terms of the composition of party. That is the reason they said it might view according to. Secondly, wherever an inquiry is refers to any provision of the code, and then we have.
Natural justice will have to apply.
But the inquiry in section 25 only. For the purpose of appointing an administrator for want of board or other things, the inquiry is.
Many of these you already addressed, Mr. Rajgopal. You repeat. Any additional thing you can say?
One submission. Cricket association, for example, what the learned senior cricket association may not apply in this case because it is mandated upon the body which was governing to hold the election within that 3 years time. They cannot sleep over and then come back and say that give me some water.
Anything additional?
Nothing. I only wanted to report.
We have no problem in hearing all arguments as long as there is no repetition. Third, Sri M.R. Rajgopal, learned senior counsel appearing for the petitioner in WP 33814 of 2025. Sri Mahesh R. Upin, learned counsel appearing for the petitioner in 33855 of 25. Sri D.R. Ravi, Sri Banu Prakash, B.G. Banu Prakash, learned additional advocate general in both the matters for the state. Sri D.R. Ravi Shankar, learned senior counsel for the intervener, reserved for judgment. Only time is a constraint, Ashte.
Serial number 36.
May it please your lordships. The challenge in this petition is to the ECIR at page 36, annexure A, and a provisional attachment order in respect of the petitioner, my lords, who is a woman entrepreneur and has nothing to do with the company under investigation except for the fact that she is the wife of the promoter. If your lordships see the ECIR at page 36, the scheduled offences that are referred are at serial number 2. There are 5. And I'll take your lordships to a table to show that 2 of the 5 have been quashed and 3 have been stayed. Now, keeping that aside for a moment, please come to the name and address of the suspected persons at serial number 5, page 37. The company is Ozone Urbana Infra Developers. Then one Shri Vasudev Satyamurthy is the director.
He is the husband.
The husband. I am arrayed at C without any description because I am not a director. I was a director for 6 months, my lords, in the year 2008. Whereas this project itself commenced around 2012, 2013. And thereafter, my lords, the other directors are arrayed. So I am brought in, I don't know in what capacity, other than my being the wife of the founder. And if your lordships now come to page 39, which is, my lords, the predicate offences which have led to this ECIR, please see when the impugned project commenced. Assessment of proceeds of crime, please see, my lords, the third bullet point at the bottom. As per FIR number so-and-so dated 9/12/24 registered at CCB Bangalore, Ozone Urbana Developers Company started a project by name Ozone Urbana Devanhalli Taluk in 2012 and buyers were promised with the project handover by 2017. Now, my lords, my involvement, if your lordships come to page 158, which is the Ministry of Corporate Affairs master data, shows 158, my lords, at 161, serial number 14, the company in question. My appointment in the last two columns.
So you were appointed as director.
15/1/2008 to 22/7/2008, 6 months in 2008. Project of 2012, no involvement with, my lords, the company thereafter. And in respect of all 5 cases, if your lordships just take my predicate at page 14 of the synopsis and all the supporting FIRs and orders of
Just one moment.
I'm so
See
sorry.
this annexure G. You retired from that company, but you are a director in the other group companies.
They are not under investigation, my lords. And there also, my term is all in some maybe 2018.
2018.
Yes, in one company. In the others, your lordships will find
Several of them 18.
possibly. My lords. We are concerned with serial number 14. There is no, my lords, investigation, FIR, predicate, or ECIR in respect of any of the other companies here. If your lordships look at 11, I was there 2006 to 2008. Then in some others, 2018, no doubt. But admittedly here, 15/1/2008 to 22/7/2008.
Yes.
Now kindly come to that table, my lords, which is at page 14 of the petition synopsis. The 5 cases which are predicate. The first one, my lords, has been quashed by order dated 7/3/2024. The second one has been stayed. The third has been quashed. Then the fourth, my lords, and all the orders are before your lordships. Fourth has been stayed and the fifth has been stayed. And this is covered, my lords, by a coordinate bench of this honorable court in Uma Reddy's case, that following Vijay Madan Lal, even a stay of a predicate offence means that the PMLA proceedings cannot go on. That position now, my lords, has been settled by this honorable court.
Yes.
Now, importantly, on this ECIR, suddenly, my lords, in October, I received summons to appear, and I am then, my lords, foisted with a provisional attachment order, which is at page 46. Please see the injustice. She is, my lords, an independent entrepreneur with her own, my lords, source of income. Page 46 is a provisional attachment which is made. Kindly come to page 122, where there is an attachment of a property. I am really not concerned, my lords, with the attachment qua the company or the other directors. Page 134, serial number 4 is a property which is described, my lords, as piece and parcel of immovable property measuring 236 acres in Mudigere. The names shown there, my lords, are of my husband and myself, and the attachment is made. Now, in respect of this 234 acres, I am the independent owner of 102 acres in my own capacity. These sale deeds were executed as far back as 2007. Praveen Dibbur's case, the Honorable Supreme Court has settled this question.
Where the sale?
Please, my lords,
But
please
you are-
come to.
You are carrying a provisional attachment here.
Quite so, my lords. Praveen Dibbur's case covers this question, that if an asset has been admittedly obtained prior to the period of investigation or the offence, it cannot be subject matter of a provisional
That would
attachment.
have to be decided by the tribunal.
But your lordships, in a writ can certainly do that. It's a jurisdictional error, because under section 5, the precursor for an attachment is there must be, my lords, a charge sheet. There is no charge sheet in this case.
The factual aspects, it's not.
No, it's a legal question.
It's not jurisdictional aspect.
My lords, the jurisdiction to attach, basis section 5, read with Praveen Dibbur's case, which I will come to, is twofold. One is there must be a charge sheet. If there is no charge sheet, then there must be a determination as to.
So your claim is only limited to this property now?
Only to this property, most certainly.
When did you acquire the title to this
Yes,
property?
2007, my lords. Please come to page 164. Project is of 2012, FIRs are of 17. 2007 sale deed, I am the sole purchaser. I have purchased for about 4 crores or so. The consideration amount your lordships find at 178. I have paid, my lords, the entire amount through my bank account or through a loan obtained by me at page 179. And the other sale deed in respect of this tranche is, my lords, of 12/10/2007 at page 188. Again, she is in her sole capacity. Now, in this background, my lords, just see
This schedule is 102 acres.
Yes, yes.
Where is the 102 acres? There is no totaling.
The schedule your lordships get at
184.
Yes, 184.
Was the total extent?
Yes.
Not been totaled.
Has it been added up? No, it's not been total, but lordships may take it. It comes to, my lords, the 102. The extent your lordships find is that.
Yes.
Now, these two propositions that I'm placing before your lordships are covered, my lords, firstly by the judgment in Uma Reddy of this honorable court. Please pass on the case. Please give. Though there is a compilation notes, I'll only read 2 orders. Uma Reddy is at page 342, volume 2. Please first come to page 26 is what? Internal page 26 of that judgment, which is at 378. 367, I'm sorry. Para 17, lordships have it, notes?
Yes.
In somewhat similar circumstances, a division bench of the High Court of Madras in B. Shanmugam considers this very point as to what is the effect of a stay order and has held as follows. The effect of an order of stay means that the operation of the impugned order is stayed or stands stalled as if the impugned order does not exist. Therefore, to bring the parties to the proceedings from taking further action in relation to the subject matter, pending the final adjudication, stay order is granted in the interest of both parties. During the currency of stay, if any proceedings are permitted to go on, and the meanwhile, if any damage has been caused to the reputation or goodwill of the parties, the same cannot be compensated. Whereas if the department waits for the final outcome of the proceedings, no prejudice would be caused to them. In all these cases, the admitted case of the respondent department is that the ECIR has been initiated identical facts on the basis of certain FIRs respectively, culminating in a quashing or a stay. So following the view, my lords, of the division bench of Madras, this honorable court in this judgment, my lords, concluded by extracting the law in Vijay Madan Lal, internal page 32 at 373. A division bench of the High Court of Madras holds that in light of the link between the two and the judgment of the apex court in Vijay Madan Lal, further proceedings under the PMLA should not be permitted to continue. And accordingly, my lords, at para 18, in the last line, if the proceedings in the predicate offence are stayed, the impugned proceedings of attachment under the ECIR cannot be permitted to continue. So this is on this aspect, my lords. Not only is there a stay, lordships.
There is also a provisional attachment?
Yes, yes.
Where do we get that?
Please see the order, my lords.
Para 4.
Please, the order itself. ED is restrained from proceeding further in ECIR so and so with regard to the provisional attachment till disposal of the writ petition. Now, my lords, on the other question regarding the acquisition of the asset prior, please come to the judgment of the Honorable Supreme Court in Dibbur's case, which is at page 311. Kindly come to para 17. At page 327.
Yes.
Acquisition of the first and second property. The allegation against the appellant in the complaint is that she purchased the property worth crores, though she did not have source of income which would generate enough money. No such allegation against me, my lords. The allegation against the appellant is that she allowed and facilitated A2 to conceal the siphoned misappropriated amounts by using her bank account. Another allegation is that she has shown to have purchased second property from A1, though she did not have resources. Allegation is that she allowed A1 to use her bank account statement. That's on the facts. Now please come to the next page, the third line. The first property ex facie cannot be said to have any connection with the proceeds of crime, as the acts constituting the scheduled offence took place after its acquisition. The case of the appellant is that she possessed a substantial amount, and as can be seen by her declaration of income, etc., under the IDS scheme, and therefore at the time of acquisition of the second property, more than sufficient money was available with her. Now, in fact, none of these allegations are even made against me. The predicate offence is of fraud against the company by home buyer saying you have not handed over some 200 odd flats out of a construction of 4,000. And on these facts, my lords, in Dibur, ultimately, if your lordship just see the conclusion in the judgment, which is at page 339, conclusions, kindly come to C, my lords. At 40, the first property cannot be said to have any connection with the proceeds of crime, as the acts constituting the schedule offence were committed after the property was acquired. So therefore, since your lordships asked me, the jurisdictional basis for the provisional attachment is there must be, my lords, proceeds of crime relating to the acquisition of a property. Admittedly, my lords, almost 7 years prior to the alleged offence, in respect of a company in which I was not a director or had any role whatsoever. And I'm now receiving summons, my lords, from the authorities to appear. Page 150 is a summons issued to me.
Who appears for the ED?
You have served, my lord, Mr. Madhukar Deshpande.
Yes. Sri Madhukar Deshpande is directed to accept notice for the respondent. The grievance of the petitioner is that one of the properties which has been provisionally attached is a property which has been purchased by the petitioner of her own funds, and more importantly, the said property had been purchased prior to the allegations made in the FIR as regards the date of the offence having been committed. And in that regard, Sri Aditya Sonil and Senior Counsel, by relying on the decision of the Honorable Apex Court in Pavana Dibur versus Directorate of Enforcement and others, 2023 INSC 1029, more particularly para 17 thereof, would submit that if the acquisition of the property was prior to the allegations made and the property has not been acquired from and out of the proceeds of crime, a provisional order of attachment cannot be made. Secondly, by relying on the decision of a coordinate bench of this court dated 14 December 2022 in WP number 19337 of 2022, he submits that in the event that if a predicate offence has been stayed, has been quashed, let alone quashed, proceedings under the PMLA cannot be continued so long as the stay is subsisting. And in that regard, he relies upon para 17 of the aforesaid order. Coming to the facts of the matter, his submission is that The acquisition of the property at CL number?
4, my lords.
Page number?
Page number 134.
134. This commences from.
My lords, the provisional attachment commences from 46.
What is the annexure number?
Annexure C.
That in terms of annexure C being the provisional attachment order number 29 of 25 dated 4/10/25, the petitioner is only aggrieved insofar as the properties at sale number 4 thereof at internal page 18 of the said order. The said properties to an extent of, out of the said property at sale number 4, he submits that an extent of 102 acres approximately has been purchased by the petitioner out of her own funds under a sale deed dated 12/10/2007, much prior to the FIR having been registered and or the dates on which the offences are said to have been committed. His submission is that the petitioner is not concerned with other properties except that covered under the sale deed at Annexure H dated 12th October 2007, bearing registration number, which has been registered as document number. Where is the document number? Document number MGE-1-00539-2007-08 and stored in CD number MGED 9 dated 18/10/2007 in the office of the sub-registrar Mudgere.
And J, my lords. There are 2 sale deeds, H
Is
and
the
J.
other sale deed?
Your lordship saw it, 188.
188?
Yes.
What is 188?
12/10/2007 again, no? Different vendor.
And a sale deed dated 12/10/2007 at Annexure J, registered as document number MGE-1-00530-2007-08, stored in CD number MGED 9, dated 15/10/2007 in the office of the sub-registrar Mudgere. The said sale deeds having been executed in the year 2000, executed and registered in the year 2007, much prior to the FIR having been registered on
FIRs, my lords, are of 2021, is it?
in the year 2021. I have the considered opinion that the decision in Ms. C. Uma Reddy and others was the Directorate of Enforcement, Supra, would be applicable. Sorry, in Pavana Dibur was the Directorate of Enforcement, would be applicable. As stated in para 14, in page 14, the proceedings in crime number 183 of 2021 have been quashed by order dated 7th March 24. Crime number 19 of 24 has been stayed wide order dated 19th February in writ petition number 4968 of 24. Proceeding in crime number 271 of 24 has been quashed by order dated 12th December 24 in WP number 27473 of 24. The first one, no? Crime number 183 has been quashed by order dated 7th March 24 in criminal petition number 245 of 22. The proceeding in crime number 77 of 2024 have been stayed by order dated 19 December 24 in WP number 34702 of 24. Crime number 161 of 2024 has been stayed by order dated 27 February 25 in WP number 27587 of 2024. Thus attracting the decision rendered by a coordinate bench of this court in Sri Uma Reddy versus Directorate of Enforcement, which in turn has relied upon the judgment of the Honorable Division Bench of the Madras High Court in B. Shanmugam's case. B. Shanmugam versus?
What's the full name of the Madras?
Will you produce that?
Is it there in the compilation? I'll just tell you, lordships.
B. Shanmugam was so and so. In that view of the matter.
Versus Karthik Dasari, my lords.
Give us
Lordships
the
get it.
citation. In that view of the matter, the provisional attachment order dated 4th October 2025 bearing number 29 of 25, insofar as property described at item number 4 therein covered by the sale deed dated so and so bearing number so and so is stayed till the next date of hearing. It is made clear that the provisional attachment order shall continue as regards the other properties, including that in serial number 4, which are not covered by the aforesaid sale deeds.
Also proceedings, my lords, pursuant to the
Needless
ECIR.
to say, any consequent proceedings pursuant to the said in relation to the provisional attachment.
And the ECIR, because they've given me summons now to appear.
That may be for something else,
No, it's the same ECIR.
but the provisional attachment only will stay. The rest of it will proceed.
Then there is a risk of arrest tomorrow. Lordships have seen, I have.
We don't know
Unless-
what other investigation is happening.
Please see the summons.
Let us hear the other side on that.
Yes, my lords, my lords, no precipitate action because the summons relate to this ECIR.
Only as far as the property is concerned, it's clear, we have stated the provisional attachment. The investigation could be for a lot of other things which would come about. We'll hear the other side and then consider.
Quite so, my lords, but no precipitate action against the woman
So far
pursuant
as
to the
provisional-
summons.
Insofar as the provisional attachment, no other action.
But tomorrow, if I am, my lord, subjected to an arrest pursuant to this summons, your lordship, just see the summons, it relates back to the
We have
ECIR.
only heard you on one side, on the ex parte side of this part. This is clear today. We
Please.
have to hear the other side before we pass that order.
Then would your lordships kindly issue notice on the
We've
other,
already issued.
other interim prayer for stay of.
As regards the interim relief seeking for stay of further proceeding with the ECIR, the same would be considered after appearance of the respondent.
Very good.
Relist on 9th December.
Please. Could my lords record that we will appear but no precipitate action be taken? Because my lords, your lordships know something off the cuff happens. This is a clear case of her being, other than the wife. I don't think there's no legal error there.
Unfortunately, insofar as this company is concerned, where Mr. Deepak Bhaskar is appearing, we have got hundreds of cases before us.
Possibly.
So we don't know what are the situations, what is the.
5 FIRs in the ECIR.
Insofar as these two properties.
I'm so grateful
Clear.
for that. Just an observation that no precipitate action be taken.
That will not be proper to do so.
Then I'll move your lordships if there is such a need.
If you move that,
Very well.
you serve it on the other side.
Very well. I'll
1 of 25 is allowed.
Great. As an aside, may I take half a minute notes? I'm told in the other matter relating to the SCST amendment, I was not informed it was moved.
Yesterday,
There's a notice in the review in Nikanti's case.
So now, yesterday it was mentioned.
Everything is at large now.
Advocate General was here, Mr. Panindra was here.
Pardon my absence. I was not aware that it was.
It was, the AG had moved it. We had not asked you to be present or anything. Now what they have said is, they'll seek for clarification from the bench of the apex court if this could proceed.
Could proceed, yes.
Because the entire argument is on Nikanti.
Quite so.
And much of the judgments there after Nikanti have been cited.
Lordships.
So if we have to refer to Nikanti and it is pending review, though the apex court has said that review will not come in, pendency of review will not come.
Ordinarily, yes, my lords.
But it will not be prudent for us to.
No, I can quite see, my lords. I will also try and support their request for a clarification either way.
Yes.
So that your lordships
I
can.
believe it is now on.
24th, I heard.
24th.
24th November.
24th. So
We'll come back to it.
if this can proceed, we have dealt with all your. Yesterday we had said 130 judgments. When we went back and saw it is more than 200 judgments.
I may be responsible only for very few.
Each of you is responsible for few.
I was telling my colleague also, we don't need a compilation. At an admission stage, your lordships need to see 1 or 2 orders. But anyway,
Collectively, all of you are responsible for more than 200 judgments.
we have to plead guilty to that. So grateful.
Yes.
So grateful.
Serial number 37, K. Chandranath Pariga.
May I? But I appear for the. Please, your worship. My lord, subsequent to the filing of this writ petition, there is a development. May I place it on record by?
Good development to settle the matter.
And not settlement.
Mr. Anif has appeared.
Lord, kindly see, what is challenge is the.
That's what, I am also not placing the same notification
On record, my lord, now let him finish, then we'll come back to you.
Elections
Oh,
of,
my lord, kindly see the prayer, my lord. It is regarding the administration of a dargah. First prayer is annexure H. The notification dated 17/9/2025. The memo may kindly be seen. That notification is that continues. The next notification is 31/10/2025. That is the election to be held on the, yes, it's postponed. Therefore, the second prayer may not survive. My lord, as regards the third prayer, that is direct the first respondent to settle a scheme of administration to the respondent number 3 in accordance with the Waqf Act. That would
Survive.
that will survive, that will continue.
Probably because now that both the groups have been, only two groups are there,
Only two groups.
thankfully. And both the groups have been called for settlement.
Yes.
If you arrive at a settlement, you can
Yes.
place it on
So
record.
kindly have it some
So
other.
you are going to be, when is the meeting?
Meeting,
Date fixed.
they have not, date is not fixed.
it is, my lord, postponed, my lord.
Election has been postponed.
Election is.
When is the meeting?
That is, my lord, on my lord, the elections are
Appear for one
on
group.
23rd.
You appear for one group. You appear for the other group, Mr. Hariga?
Yes.
My lord, yes, I appear for,
When will you fix the meeting? Both of them?
no,
are-
not he, the board.
Board has to fix the meeting.
The board has
We are
to fix.
asking Mr. Malli Patil. When
No,
he
he appears for electoral officer.
Electoral officer.
Yes.
Mr. Malli Patil appears to the
R5.
board. alone.
No,
Lord,
Let
now,
him
my
answer.
lord, board has not been notified, my lord. Earlier, my
So
lord,
you are
K-Wait
appearing
was
for the
filed, my lord.
institution.
he appears to the, for the institution and election officer.
Election officer.
Election officer.
See, P. Usman is directed to accept notice for respond number 1 and 2.
I
So
think,
P.S. Malli Patil, who
Mr.
has filed K-Wait for respond number 3, accepts notice for respond number 3. Registry is directed delete the name of Shri Anand Kumar M. as that appearing for K-Wait to respond number 3. What about 4 and 5?
My lord,
Will be Mr. Usman.
K-Wait
belongs to the core institution, I mean, board.
Board.
K-Wait was filed for 4 and 5.
No, only for 3. K-Wait has been filed only for 3.
4.
P. Usman for 1, 2, 4 and 5. You filed a pleading application. When did you file it?
Today morning. It's not.
Any objection for the pleading?
Yes, my lord, I have objection.
If you have to settle the scheme, we have to hear him, Mr. Hariga.
Oh, if the scheme is settled after hearing both the parties, then.
If there is
yes.
settlement there, there is no problem.
Yes,
But if doesn't settle here and we have to consider your scheme
Yeah.
for settlement, we have to hear Mr. Hanif.
whether he will be a member of this institution, my lord, because the fight is between the two factions.
Correct. He is representing the second fraction.
Present management committee, general body members.
Which
We'll
is
have to
not
hear
in
it.
existence.
Scheme approved by the board.
Administrator is appointed.
My lord,
You are representing only one faction.
I
The
represent.
other faction has to be here for settling a scheme.
My lord, I would like to file objections. Anyhow, lordship
No,
is,
no, if you are looking at objection, then there is no settlement which will happen.
no, the board has to call for a meeting now.
We'll get the board to call for the meeting.
Yes,
But if you don't even want to come, them to come here, you are not sending the right message
my lord.
for a settlement. You are sending a message for a fight.
No, my lord.
To fight, you are
we-
welcome to do so.
We always stood for settlement, even
Allow him
before.
to come on record, so that
Yes,
he is
let him
there.
come.
IA 2 of 25 is filed by one other faction of the third respondent. The dispute being between two factions, I am of the custom opinion that the other faction would also have to be represented in these proceedings, considering more particularly prayer C, which has been sought for. Hence, IA 2 of 25 is allowed. The person named therein are brought on record as respond number 6, 7, and 8 respectively. Counsel for the petitioner to carry out necessary amendment and file amended cost act. A memo has been filed by the counsel for the petitioner enclosing a notification dated 19/11/25 in terms the said notification indicates that in the special meeting of the board or the first respondent held on 23/10/2025, it has been resolved to call both the groups to
discuss it regarding the scheme to be formulated.
is resolved to call both the parties for possibility of a settlement. And in that background, the election to respond number 3 has been postponed. It is now for the first respondent fix a date and time for the meeting between the two factions.
An application challenging the notification, prayer of before this already pending before the tribunal.
Which notification you challenged before the tribunal?
Same prayer.
I have not filed.
Who has filed it?
Another set of petitioner.
Are there only two factions or more than two factions?
It belongs to them.
That may not be correct, may not, we have not filed. We are before this.
Meeting is required to be fixed by the first respondent.
Yes.
Matter has to be go to them and the Lord's 83 is clear on it.
You want to fight or settle?
I won't, because the pursuance of the order of this honorable.
Before you take up this matter or before the tribunal takes up the matter, attend the meeting of the first respondent and see if we can settle it.
The pursuant of this honorable court's order, the bylaw was approved by the board. Once again, there is some issue was raised by the court.
See, the courts are here to try and resolve and adjudicate the disputes. If you still want to continue to fight, we'll still do our duty. If you try and resolve the matter, both of you can resolve it. If you don't want to resolve, if you make that submission, we'll say, okay, now only you file your objection, we'll take up the matter. Both of you don't seem to be very keen on settlement.
A scheme of management need to be in place as per the statute. We are agreeable for that, provided there is a meeting.
Anyway, model bylaws have come about.
Yes, let them know.
The scheme will be more or less as per the model bylaws with some
Yes,
minor
ma'am.
iterations
Yes,
that could be done.
Very, very minor.
Minor. The discretion is very limited now.
Yes,
IA 1 of 25 is allowed. Released on 11th December.
please.
The respond number 1 is directed to convene a meeting before the next date of hearing.
B group matters.
Can a sentence be added to formulate a scheme? To formulate a scheme.
Convene a meeting, both of you discuss there.
Please.
Serial number 38.
38, my lords, in this last occasion, lordship has directed me that the commissioner has to be represented by some other advocate. I have already handed out the wakalat to this commissioner. I in the morning had called them. They said that they want 1 week time to engage some other advocate.
The request of Learned Counsel for respond number 1 and 2 released on 11th December.
Much obliged.
39.
Interim order earlier granted is extended till next date.
Lords, this matter, senior is held up in another court.
39.
Please, ma'am.
I appear for respondent.
What
I have
is
to
the matter?
counter, I have to file.
Is it a
Lordship may
surface
kindly-
matter or what?
Three.
Surface matter. Then it won't be before us. Both the councils submit that the matter relates to a proceeding on Surface Act. Registry is directed to place the matter before the appropriate bench. Surface is now before another court.
What forfeiture of the money?
Surface, any action on
Surface,
surface is before another bench.
Obliged.
40.
It is time for the petitioner. Last night appearing directed the government delegate to conduct his survey. Then what happened?
Report has to be conducted.
Survey ಆಗಿದೆಯಾ?
That information I called him, but he did not pick my call. I will, 5 days time maybe.
He did not pick your call. And AGA submit that he is yet to receive instruction as to whether a survey has been carried out. He seeks for a week's time to obtain such instruction. If a survey has been carried out, the survey report on record, released on 9th December.
Obliged.
Interim order ಇದೆಯಾ?
Interim order.
Interim order earlier granted is.
ಅಲ್ಲ, interim order ಇಲ್ಲ ಇದ್ರಲ್ಲಿ. Sought for direction to consider my permission to cut and remove the trees.
41.
For petitioner. Lord, in this matter, my lord, he challenged the impugned selection, my lord. I have to file an objection in this. The
practicing advocate, he has applied for stipend
Stipend.
under 2A category.
2A type. And AGS seeks fund is granted 2 weeks time to file a statement of objection, objections if any, by 17 December, released on January on date.
9th January. 42.
Not in 42, my lord, there was a direction to me and also if the
petitioner in this
instruction is
case.
not received, the.
But I'm
Correct.
filing the withdrawal.
RFI has got it done.
No, the issue is that, my lord, that was reserved for not to grant lease, my lord, for the reason that
So voluntarily withdrawing the matter.
ಇಲ್ಲ,
Yes, my lord.
voluntary ಇಲ್ಲ.
By the instructions. of
The cause is very good, my lord. ಬೇರೆ ದೇಶದಿಂದ ಪಕ್ಷಿ ಬಂದ್ಬಿಟ್ಟು ಅವಕ್ಕೆ ಇಲ್ಲಿ ಇದು ಆಗಿದೆ.
But why do you get into this?
Public.
Petitioner is before this court seeking for the following memo of withdrawal has been dismissed as withdrawn.
Public.
Come back.
Serial number 45. Serial number
68 early. 69. 69.
Yes, I appear for the respondent. Well, it has become infructuous, my lord.
69.
Petition was challenging a particular order, my lord.
Dismissed as infructuous.
Serial number
Memo is-
45, Your Lordship. Pray for short, pray for short accommodation.
45, they have taken time several times. ಒಂದು ಕೊಡಬಹುದು next week ಅಲ್ಲಿ.
Samir, ಇವತ್ತು ಅಜ್ಜನ್ ಆದ್ರೆ it will go to 15. December or January?
November end.
November end we won't get. 15 December or 17 December? 15 December.
My lords, serial number 18, my lords, your lordship had
80.
1818, my lords.
18.
Yes, your lordship had directed us to serve a copy on the learned counsel appearing for the National Medical Commission, my lords. We have served lordship at 2:30, my lords.
Yeah, we'll take it.
Yes.
Let Mr. Shauri get his instructions.
Yes.
And
Only
tomorrow,
issue is this order is also appealable.
but on Saturday, the doctor's license will be revoked or suspended.
Yes,
So that is why
Suspended for 3 months is the
3 months,
order.
my lords.
it starts from
Yes,
Saturday.
my only concern is they did not entertain their application.
Find
You
out,
got- Yes,
get
I'll
your
get-
instructions, we'll see it in the
Yes.
app.
My lord, 108.
108.
ಫಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಕೊಡಿ ಸ್ವಾಮಿ, ಯಾವಾಗ್ಲೂ ಬಂದು ಹೋಗ್ತಾ ಇದೆ ಇದು.
108 orders ಅಲ್ಲಿ ಇದೆಯಲ್ಲ?
ಇಲ್ಲ,
Orders ಅಲ್ಲಿ ಇದೆ.
ಅದು
Non-compliance of office objection ಇದೆ.
ಎರಡು
108.
ನೆನ್ನೆ 108
It is for non-compliance of office objection.
ಎರಡು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದೇವೆ ಆಲ್ರೆಡಿ.
108.
And report was sought from the SHO actually. The report has come.
For what report has been?
Clarification on the complaint, police protection we have sought on the property and as well as the.
Learned counsel for the petition submit that office objections have been complied with. Registry to verify. Relist on 9th December.
Serial number 51, this is that railways matters.
51.
51, please, my lord.
Huh?
Fellows had ordered to conduct a joint survey. In fact, yesterday we were informed that the survey report is not ready.
Yes, yeah, who is appearing?
The Department of
51.
Department of Railways it is, my lord.
Survey ಆಗಿದೆಯಾ?
Fellows, we participated.
ನೀವಿಲ್ವಾ?
Survey agida Swami, but we were informed that survey report ready.
Central government council is not, what do you want now?
Let's, if survey report is not ready.
We don't know until we hear them.
No,
You
Mr.
want
MD
adjournment?
No, my let's,
Then
Mr.
wait, please.
My lord, item 61, 6-1.
6-1.
You're making a joint request. my lord.
Yes.
The other side is here. We are making a joint request for a second week of December.
Second week of December. The request of both the councils relist on 15 December. Who is appearing for respond number 4 now?
Abhishek Kumar.
Shri Abhishek Kumar has entered appearance for respond number 4. Delete TP Rajendra Kumar Sungay has that appearing for respond number 4.
So much of serial number 44, my lord. Survey report.
Okay.
44 survey ಆಗಿದೆಯಾ? ಆಗಿಲ್ವಾ? ಡೇಟ್ ಯಾಕೆ ಆಗ್ಲಿಲ್ಲ? So when will they have the time to do it? Otherwise, sumne we'll fix up a time and it won't happen. And learned AGS submit that due to the preoccupations of the assistant due to other official commitments of the assistant conservator in uploading the data onto the websites, the survey could not be carried out. He submit that if a fresh date is fixed, survey would be carried out and report furnished.
May kindly be interim order.
In that view of the matter, the jurisdiction ADLR with the assistant of the assistant conservator forest and the assistant commissioner revenue are directed to carry out a survey of, as indicated earlier, commencing from 10:30 AM on 8th December and submit a report by 18th December, released on 18th December.
May kindly be interim order.
Interim order earlier granted is extended.
Serial number 89 minutes. I'm for petitioner minutes. Kind of December 2nd or 3rd.
The next date is 15 December, 18/9.
89 minutes. It's a tender matter.
89 IA 1 of 25 is allowed at the request of counsel for the petitioner released on tender matter.
Please, ma'am.
When is the last date?
There's an interim order, madam.
Interim order is that. Then 15 December interim order earlier granted is extended till next. Then urgency.
Sir, serial